Hey, I'm going to take you into the intro and then I'll be right back.
Home in the valley, home in the city, home isn't pretty, ain't no home for me. Home in the darkness, home on the highway, home isn't my way, home I'll never be. I'm burning for you. I'm burning for you. Time is the essence, time is the season, time ain't no reason, got no time to show, time everlasting, time to play these sides, time ain't on my side, time I'll never know. Burn out the day, burn out the night. Now I want to tell you what's wrong from words right. I've seen suns that were freezing and lives that were blue. But I'm burning for you. I'm burning for you. Burn out the day, burn out the night. I can't see no reason to put up a fight. I'm living for giving the devil his due. I'm burning for you. I'm burning for you. I'm burning for you. I'm burning for you.
Alrighty, well, that intro went faster than. Anyway, I don't know who's all here. I don't know who will all be here because of the topic. But we will also be talking about some shit, some YouTube drama. So, yeah. Hey, Catherine. Hey, Darby. Hey, Beeps in the Bushes. I just wanted to go over the defense rested today in the Karen Reed case. I don't know. She did a 2-minute thing on the news, which we will watch. I knew she would take the stand, even though I was hoping for it. Oh my, that would have been something. She thinks her case was stronger in the retry. Ooh, I don't know. I guess that's a matter of opinion. Oops, no. I don't know if I'd call it stronger. I mean, yeah, I don't know if I'd call it stronger, but that's just my opinion. So how's everybody? How you doing today? It's been rainy here all day. It's a hump day. It's a hump day. And TurtleBoy is in court right now. There's a possibility he could end up getting his bond revoked, or yeah. See, court TV is so biased. In my opinion, I think they're very biased. Lawyer, saying it's great results for the defense. I'm not so sure. I don't know. Commonwealth had a lot of great moments. Oh, Karen Reed telling her story. Did you guys watch any of that? I was like, yeah, okay. Okay. But let's hear what she had to say after court today, because today, everything, defense rested. I don't know if the prosecution, the state, I'm sure they'll have some rebuttal. And then it'll be going to the jury. Ooh. I don't know. I don't think this time I just don't think there's going to be a hung jury this time. But here, we'll listen to this. Oops, wait a minute. Let me share screen. This is her coming out of court. I wonder if she's going to be selling her clothes again for astronomical prices, and people paid for it. Lori Vallow, yeah, that's the judge was not real. Judge has not been happy with Vallow at all. You thought they said they might have, and I just might have. Yeah. Well, I don't know. I don't know, man. That's the one witness. I don't care what anybody thinks. Here, I gotta get. Sorry if it's noisy. I gotta get the cat a treat out so he'll let me let my cords alone. I have to bribe him. Yeah, but her antics in that courtroom. Oh my god. I mean, I don't see them not finding her guilty, Lori. I really don't. I mean, if she tried to give the impression that I'm not sure what impression she was trying to give the jury at this point. Okay. This is Karen walking out after a long day in court. And, time for the jury.
Karen, you ready for closings? Karen, you ready for closings?
He was terrific, as always. Honest and stood by his analysis and answered truthfully.
Are you ready for closings?
I'm ready. Yeah, I'm ready.
Why 90?
Okay, Karen, you're so full of yourself. Do you know, the jury also will take into consideration he's a paid expert. You could put up 20 different experts that'll say different things because they're paid. I don't know. We'll listen to it. I thought they weren't putting them on, but they did.
90 minutes. What can we expect to hear?
All the facts, all the truth, everything that went wrong with their case.
What do you make? Oh, sorry. What do you make of the prosecution not calling any rebuttal witnesses?
They don't have any analysis and they don't have any facts to present through Dr. Welcher, so they're done.
Karen,
What do you want the
Karen,
jury
you
to
said
know?
before you have butterflies at this stage. Are you
I do.
feeling those?
Yeah, of course.
You think your case is stronger this time?
I thought it was strong last year. It's stronger. Yes, we just called more witnesses and laid out more of the case.
How do you feel about the jury?
I feel good about the jury. We selected them. I was there. I took part in it, and we chose fair and truthful, civic-minded citizens.
What do you want the jurors to know as they go get their instructions?
I just hope they were listening. That's all I can ask for. They were in the same room I was for the last, I don't know how many days I was, 30.
31.
Given what we saw play out in the last trial regarding the verdict forms and what we now know that the jury found unanimously came to a conclusion, what are your concerns going into it this time around?
Obviously, after what happened in the first trial and what we heard from the jurors that came forward, we just have to have an even keener eye on the verdict form and the jury instructions.
Can you
Okay, guys.
talk about the
Here we
decision
go.
to switch to the police investigation to focus
No
more
more
on
questions, guys.
Thank you.
Defense
Wow.
attorneys have rested now in the
All right. And this is the next one. We'll watch this.
Karen Reed trial.
Their final witness explained today why he doesn't believe Reed's car hit John O'Keefe the night he died. WBZ's Christina Rex is at the courthouse to show us what happens before this case goes to the jury.
I'm ready. Yeah, I'm ready.
Ready for closing arguments. After 31 days, the jury will deliberate starting this Friday. Karen Reed's thoughts on her defense's case.
I thought it was strong last year. It's stronger. Yes, we just called more witnesses and laid out more of the case.
The defense rested Wednesday and testimony is officially done. The defense's final witness, Dr. Andrew Rentschler, an expert who analyzed John O'Keefe's injuries and whether they came from a car crash.
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV.
Then how do you argue with all the cell phone data and stuff? How do you argue with all the data? It shows that she hit him.
And then moving laterally into the yard and falling backward.
He says there was no crash based on the victim's injuries and what he believes was faulty testing by a prosecution expert. The last day of testimony was filled with dramatic moments, including early on when the witness wished his son a happy birthday, live on the stand.
Happy birthday, Kai. And I have two older ones.
All right, we're gonna stop this. Another example.
Go ahead. Less editorializing.
Minus all the personal.
I'm sorry, Your Honor.
This awkwardness continued all day.
Is that funny?
No, it's not funny.
Okay.
So I'm going to strike the comment.
Now that you've shared your opinions, can I get back to my question?
Sustained.
If you watched this trial on live stream, you may have seen this fan shot a lot. Lawyers and the judge went to sidebar 14 times on Wednesday, leaving the jury waiting.
Jurors, I apologize that took so long, but it was necessary to do rather than sending you out.
The real tension came during an extended cross-examination where prosecutor Hank Brennan tried to challenge Dr. Rentschler with other pieces of evidence, like O'Keefe's hat or a broken drinking glass found in the snow.
I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard.
You don't know the position of Mr. O'Keefe's arm at impact, do you?
nobody knows. I don't think his arm was even impacted by the cars.
Moving forward, Karen Reed says she's nervous about another hung jury in her second trial.
After what happened in the first trial and what we heard from the jurors that came forward, we just have to have an even keener eye on the verdict form and the jury instructions. I just hope they were listening. That's all I can ask for. They were in the same room I was.
So the way the defense rested might have been a little confusing. The defense says it rested, meaning no more witnesses, subject to one more evidence issue. So that's going to be argued with just the lawyers and the judge first thing Thursday morning. Then they'll discuss jury instructions, so no jury on Thursday. Then closing arguments set for Friday. In Dedham, Christina Rex, WBZ News.
So you're going to step up, face the court, and raise your right hand.
You solemnly swear the evidence to give to the court and jury in the case now here to the truth.
Okay. Which one was it? This was 2 days ago. This was the private investigator. I want to recap today's, though. And then we'll go back and look at other days. I know I have it saved. Oh, that can't be it because it just rested. Yeah, that doctor's testimony was something. He was very defiant. Very, very defiant. For TV saying Karen Reed, special prosecutor, misled the jury. Defense calls its last witness on day 30 of Karen Reed trial. That's what I want. Well, I don't want the whole 7 hours, though. I have the shorter version. I don't know. There's a chance that she could get off. Of course, she won't testify in her own. And it would have been nice. The dog bite theories, the mistrial drama, and forensic clashes that raised, heated arguments. But that doctor, this alleged, he was in it. Oh, and Dr. Wolf and Arca shakes up the Karen Reed trial. All right, here we go. I want to watch him because he was really difficult, it seemed, in all the clips that I've seen. Hey, Sheena. Hey, Nanas. So what do you guys think? Some of you have been watching it. Do you think she did enough, that her defense did enough to get her off? Do you think she's going to be found not guilty? Or do you think the state has presented enough evidence to secure the conviction? I mean, you can't make up. How you doing, Nana? You can't make up the what, baby? Hi. You can't come out, but hi. Blowed your kisses. I know, but you can't come out. You can't come out. No. Sorry. Go play with Uncle Frank or Mommy or one of the kids. She wants Aunt Kathy. Yeah, that Dr. Wolf, excuse me. Yeah, that Dr. Wolf was a real, he was arrogant, that's for sure. I considered him difficult. I want to watch his testimony again. We're going to watch the highlights of it now, and then we'll move on. Oh, she's not, she boiled. I think the state did more this time, but I don't have a clue what the jury is thinking. Yeah, they definitely did better than last time. But you can't, how do you just dismiss the data evidence that they have? I mean, from, paid witnesses are just that, paid witnesses. He's given his theory on what happened. It doesn't mean that that's exactly what happened. Just like, I don't know. I can't totally agree with him. I can't agree with him because of what the data shows. You think you turned the jury off with his antics? Yeah. Yeah, he was very difficult. Which wasn't very professional. I mean, he didn't like being questioned. And that's part of being an expert. Your so-called expert opinion is going to be picked apart. That's the game. It's what you signed up for, dude. Okay. Oh man, I was really bummed out last night. Man, I had it all set. I just knew that Brittany and Craig was going to get on there, and Craig was going to just have a field day with his mouth and his ideologies on stuff. Ideologies, I should say. But no, she went out. Okay.
On a bit lifeless in a snowbank outside of 34 Fairview Road in Canton, Massachusetts. His body was discovered the following morning, bruised, battered, and partially covered in snow. According to prosecutors, his girlfriend Karen Reed dropped him off at a house party attended by fellow law enforcement officers. They allege that after a night of drinking, an argument erupted and Reed struck O'Keefe with her SUV, leaving him to die in the freezing conditions. Charged with second-degree murder, vehicular manslaughter while under the influence, and leaving the scene of an accident, Reed has maintained her innocence. Her defense argues she's being framed, pointing to a cover-up with law enforcement.
I go with the vehicular manslaughter and leaving the scene. Those two charges should stick. Because there's no doubt in my mind that she hit that man. She hit that man. That's just my opinion. Yeah, he didn't make it. He was very cocky. But I'm going to go over what happened in TurtleBoy's hearing today as well. There's a chance he could end up back in jail, according to what, people are saying. And what's going on in court. I mean, because he is out on bond. And if he gets found guilty, then of course they're going to have to revoke it. I mean, that you would think. I don't know. I don't see him getting off scot-free with all the charges he's facing, and there is proof. There is proof. I don't know. And with his arrogance too, just like Karen, they're so arrogant. I mean, he's acting like this is in the bag and nothing's going to happen, and he's going to be fine. And he continues his behavior. He continues doing the things that got him put in jail and got him in court and all this mess in the first place. Yeah. Hell, she should have pled this out. She'd have been done out of jail, probably even on probation if she would have had any, and on with her life. And you know, I don't believe she's in debt. I think she gets plenty of money to pay the legal defense, or they still wouldn't be there. But I think she gets plenty of help, or at least did. But yeah, she could have been on with her life, and now there's a chance she could do a heck of a lot more time.
Consistencies in the timeline and handling of evidence.
I'll be right back.
The case has gripped the public, fueled by viral social media debates and allegations of a botched investigation. And tonight, we are live from the courthouse after a day of important expert testimony and compelling video recreations of the alleged crime as the retrial of the century continues. I'm Vinnie Politan. Great to have you with us here on Closing Arguments as we close out another week of the retrial of the century. Karen Read on trial for the murder of her boyfriend, John O'Keefe. Let's talk about expert witnesses. You know, sometimes they cancel each other out. You know, each side has their own, but sometimes experts can win a case. Are you doubting me? You don't believe me?
Exactly.
Do you watch Court TV? Do you watch the high-profile trials?
Vinny, I definitely, I don't have any faith or trust in your reporting. I've learned not to, Vinny. You are not neutral at all. You can be very biased in your reporting. And you've slummed it with some of the scum. Sorry. It is what it is. Hey, TV. I like that. Horse TV. That is so cool. I like your name.
Here on Court TV, because I'll give you two great examples of an expert coming in and winning the case. And at the end of the case, everyone turning to one another and saying, wow, that expert witness was the star of the case, was the star of the trial. That's what turned it. And you could listen to some of the jurors afterwards and hear from them. I'll begin with Dr. Martin Tobin. Remember him? He was the expert talking about how George Floyd died in the trial of Derek Chauvin and others. This was a guy who wasn't your normal expert witness. He didn't have a lot of history testifying as an expert, but what happened to George Floyd was in his wheelhouse in being able to explain what happened. And he explained so artfully and so eloquently and made sense to everyone that was watching, including the 12 in the box. And that case was won because of this expert, because a big issue in that case was the cause of death of George Floyd. How did he die? Why did he die? And Dr. Martin Tobin was able to explain that to the jury in a way that resonated. And it made him the difference in that case. Okay, maybe you don't remember that one. How about a little more recent? Dr. Ken Kinsey? You remember him? The forensic expert in the Alec Murdaugh trial? The one who put all the pieces together to show the jury how the shootings took place. I mean, he left the defense reeling to the point that the suspect, according to the defense, had to be like 5 feet tall that they were looking for. But he was able to explain it. And it made so much sense. And the overwhelming response by the public and obviously the jury to his testimony made a huge difference. And experts make a difference. But let's talk about Dr. Daniel Wolf. This is one of the ACA guys. The ACA guys being called by the defense on behalf of Karen Read. We thought he was an important witness in the first trial until we spoke to the jury who discounted his testimony because they didn't know why he was testifying, who had hired him, because the court didn't allow the jury to know that he was hired by the FBI and by the feds to investigate this. They still don't know about that. But at this point, he's being paid for and being brought as an expert on behalf of the defense. So the big question is, can he make a difference for the defense? Can the defense win the battle of the experts to raise a reasonable doubt? Or is the prosecution going to win the battle of the experts to prove something? Tell me about the direct testimony.
Well, we're nearing the end of the defense case, right, Vinny, in the courthouse here behind me, and such a big day and a big witness, much anticipated, anyone that's been following this case. So you had the crash reconstructionist who you mentioned.
Okay, I'm going to let this play while this video is loading. This isn't exactly what but yeah.
Wolf, and he is with the ARCA company. He testified last year, but this year, very different. And it kind of puts into perspective all of those outside of the president's arguments over his testimony and his new findings, because they're really based on the crash reconstructionists newly hired by the Commonwealth, Aperture. Their testimony about their paint, the blue paint, and their testing with an exemplar SUV at 2 miles per hour. Well, he takes their findings and adds more G-force behind it.
I'll show you what we'll come back to this. I want to show you what he's talking about. I believe it's in this video. And then we're going to bounce so that I can show you. I didn't have time to put it all together, unfortunately. I actually do chase children around all day. Oh, that was the wrong one. Damn it. Don't want to go back to that one yet. But I want to show you this testimony, where you'll see clip pieces of it here. But I want you to see the private investigator. I want to hear too again. I missed some of his. This guy was the biochemist. Here, we'll watch this. Hopefully they'll play the interview. This is on the biochemist, the dude with that had a bad attitude. I'm sorry, but he was cocky as hell. And then I'll play that other one. But this is, I want to hear the private investigator again. But I want to show you the ARCA when they did the dummy and stuff. I want to show you that. Okay.
On Mr. O'Keefe's forearm.
Did this test, in your opinion, establish force multipliers that were exerted on the taillight?
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. O'Keefe did not have lacerations on his arm.
What did he have?
He was diagnosed with superficial abrasions.
Is there a difference between a laceration and an abrasion?
There's a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is. The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
So I strike the end of that.
Would you describe the injuries on Mr. O'Keefe's arm as lacerations?
No.
Would they be more properly described in another way?
It
I'm
would
sorry,
be, yes.
I will stay muted because of my little. But what I said was what he just said. Lacerations are deep openings in the skin, deep gashes in the skin. Abrasions or surface are usually the first couple layers of skin, like a brush burn or something. But he just clarified that. Sorry. I have to mute when the little comes out or comes to the door crying for me. Yeah, we're gonna watch the reconstruction after this. The other guy, that I don't know. I'm still, no matter what, I can't get it past the data. I can't get it past. And I remember the first time we talked about this trial was me, Hills, Voices, and I don't remember who else. Somebody else I think was up there with us too. And I didn't know a whole bunch. Not like Hills did. And we were going over the first timeline that was thrown together. And I then even had a hard time with some of the issues, like that we knew of, because there's a lot, we know now that we didn't know then. But, one of the things which was weird to me was, the phone calls and stuff, just between everybody. But anyway, the ones that we knew about, but like Jen and John, it was just so weird. But I do believe that they were having an argument. You can look at Karen and tell Karen can be a real bitch. Okay. And my guess is a very mean drunk. They were drunk. No doubt about that. They were all partying. They were having a good time. I don't think these two were having a good time towards the end of the night. I think Karen was pissed that he wanted to go there. And I think part of that reason was because of who was there. But again, just my opinion. And I don't think John ever made it to the actual house. I don't think he ever made it to the door. And I don't believe he ever went inside. I don't believe he made it further than getting out of the car on the road. Now, whether it was on purpose or not, I think, come on, you drive, you guys drive. Have you never revved up your, threw it into gear or just hit the gas pedal because you were a little pissed? That could have been the situation, but why reverse? I don't know. I think that she knew exactly where to find him because she knew where he was. And I think that's why she could easily find him when others in the car couldn't. And yeah, I think she's guilty. I think it should be at least manslaughter and the other charge, which could be a felony, leaving the scene. Because we don't know. No one can tell you, honestly, if John would have recovered or, what would have been, with the head injury, what would have been, his state, how, but we'll never know. We'll never know. You don't think she's guilty, Shauna? Okay. Hey, B. Tim, you want to come up? I've just always thought, just from the get-go, even before all the, I'm talking about from the very beginning, that first very night on Hills, my gut tells me this woman is a very angry drunk. They were fighting and he got hit. And yeah, and I think they were all tipsy. They were having fun. But I wanted to go over the reconstruction scene and this guy, because this guy is so freaking cocky. And I might just go to the trial itself, and I should have got the timestamp where he actually started, because they're only going to show us some of it. I don't know if they're going to show us, enough. But anyway, let's get back into it. What makes you not think she's not guilty, Sean? I'd love to hear. I like it when people have different opinions and we can talk. Okay.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin.
Like a brush burn.
Now, a laceration is a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis.
Right.
So abrasions take much less force. They're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it proper to get the...
But you got to understand, you're not... What you should have clarified is a gash or a laceration is not going to look like an abrasion. But a lot of people, and I know because I worked in the medical field for years, so it's not uncommon for it to just be called an abrasion, or, it's not, or, a laceration when it's an abrasion. You can definitely tell the difference between, let's say, a brush burn and a wound that's going to require stitches,
Important to get the proper injury.
You think they're dog bites? There was no dog DNA there. I don't think they were dog bites. There was no dog DNA. And then the defense dropped all that too, because they knew. But you could be right and I could be wrong. Who knows what they don't know what the jury's thinking? I can't tell you what the jury's going to do, because they even heard things that we didn't get to hear at the sidebar. I'm sure they heard some of it, and then they're not supposed to consider it, but come on, you're human. And man, I'd have liked to have been a fly at some of them sidebars. I really would have. Yeah, I've treated dog bites, and a dog that size. It was a German Shepherd. Actually, it was a police dog, in the field. And I've seen dog, I've been bitten, and, people in my family have been bitten. And, yeah, I don't know. Like I said, this jury's I don't think it's going to be, I don't know. I don't look for it to be I'll be surprised with everything, because there has been a lot of evidence and circumstantial evidence. There's been a lot of things presented, and they were allowed to use those interviews. Those interviews are going to hurt Karen. Their own one witness who called them out when she was on the stand and said, no, you did, that could hurt them as well. I don't know. There's a lot. But then, they had gotten some points as well that could hurt the state's case. So the jury's got a tough decision to make. I mean, it's somebody, no matter what, it's somebody's life. And, there's a family waiting for justice because a young man's gone that shouldn't be gone. Was it just a total, a real true accident? And she was just afraid because she didn't want to get a DUI. I don't know. Or she thought he wasn't that hurt. I don't know. Could be. Or is the theory they're putting out true? That, there was a fight in the house and the dog bit him and blah, blah. I don't believe any of that, though. It just doesn't. John didn't enter that house. I just don't believe he ever entered that house. Or was it in a fit of anger that she threw her car into gear and hit the gas pedal. And just left, never looked back, just left. But she would have had to throw it into gear again to take it out of reverse. And then she knew, I mean, she knew right where he was. And I believe the stuff she had Jen look up. I don't know. Like I said, this jury's got a tough decision, and I don't think it's going to be a quick one. My son had marks like that, and he was attacked by a dog. I don't know. There was no dog DNA. I know that.
To the body as a foundation to the entire analysis?
That's core to the analysis because you're trying to determine how an injury occurred. You have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up. First step in the analysis. What is the first step in the analysis after you determine the injuries, the type of injury?
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. O'Keefe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is
the plow guy, I still question all that too, but he didn't see him, but yet Karen knew exactly where he was. Kind of strange.
Determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions and lacerations. The laceration is on the back.
This guy was even worse than Dr. Wolf, in my opinion. This guy was super biased and seemed to made up his mind. I also think he perjured himself on the stand. Also, the happy birthday to his kid on the stand was weird. Yeah. Well, thank you for that, B-Tim. But I dropped the link if you want to come up. Thank you very much for the $20 super chat. I appreciate that.
The skull on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere.
I think. Do you think so, Shauna? That's possible. Like I said, this case, I have not seen enough evidence to change my mind, but I'm not on the jury. I have no idea what to do after closing arguments, because closing arguments can, if a juror is on the edge, closing arguments could, just give that little nudge. I don't. Like I said, the jury's I don't think it's going to be a quick verdict because I think there's going to be a lot to go through, and then they're going to be really extra careful because of, they're saying that the whole mistrial was over the jury form, and the defense is saying so. Yeah, it was bad weather.
Where it talks about the extremities, it's superficial abrasions.
Please don't believe the stuff that TurtleBoy and his Karen Reed nut jobs to put out. That's all I'm saying. Just please have an open mind. And Sean, thank you for even talking to us, because most people won't want to talk back and forth.
So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see see, there's a picture of the actual abrasions.
Hold on, Brad.
Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the
Are you
sources that are
Brittany?
reflected on this slide that you referred to?
Okay, let me take the shield down. Okay. Hi, Britt. How are you?
Hey, thank you for doing this live stream because you and B10 got me interested in this whole case and now I'm invested.
Oh, okay. That's who. Yeah, I got pulled in the same way. It was Hills.
Like, you and
Hills in the air.
B10 started talking about it and I was like, now I'm intrigued. Now I must know more.
This is one trial I wish I could have streamed, but I couldn't commit to it every day that they streamed, because of my littles and stuff. And, then I got sick, so I definitely would have I missed a whole, missed 2 weeks. So, yeah, this is one now I wish I would have. You can bet I will be anything that's being showed on TurtleBoy.
Okay, so I've got a question, and it goes for you and B-Tim and the rest of the chat. She has health problems, correct?
They claim, but she seems as healthy as a horse. Sorry, I'm closing up the cat treat. They've claimed different.
Sorry, I was going to say the only reason I asked that is you don't think they could use her health to get her out of jail, do you?
No,
Okay.
It's nothing like, no.
Okay.
Honey, they put people in jail that have cancer. People stay in prison that are terminal with cancer. Yeah, that's not going to matter. And she doesn't have nothing like that. So, yeah, no, that's not going to have a bearing on it.
Okay.
So you want to hang out while we play some more of this? You're more than welcome to. Did you already jump down?
Yes, I want to stay.
Okay.
I was muted. I'm sorry.
No, that's okay. These are the wounds which I have went over these before. Oh, a long time ago.
Can I say one thing? This is so much more interesting than Brittany or Betty.
Yeah, sometimes you just need a break.
Yeah.
And Queen had me laughing my ass off. I got to listen to like the first part of her live, and then I get pulled away and I get lost, and I have to start over. But she had me laughing my ass off when she first got started. Oh my Lord. She won't shut up. She deserves what she gets. I mean, Brittany's asking for it. What can you say? Okay, let's get on with this. YouTube dramas after all this. Guys, this don't look like dog bites. And, being in EMS for so long, I've seen how, I don't want to be morbid here, but I've seen plenty of car accidents, and the underneath and the bumper underneath can actually cause some weird markings on the skin. And I don't know. It just don't look like dog bites though. I don't know. But that's just my opinion.
Relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken.
Are autopsy records, hospital records, medical records acceptable sources for biomechanists to rely on in determining or coming to opinions and conclusions?
They are the sources you go to determine what the injuries are. Yes.
Did you see? You reviewed the entirety of the medical records as well as the entirety of the medical examiner's file, is that right?
I did, yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits.
Yeah, I've never been in a big plow truck like that, but I'd imagine as high up as that they sit, you probably could pretty much catch everything. I mean, the ones that we used to have back home, I mean, they were big ass trucks. Yeah.
The X-rays.
Okay.
So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
This is an exhibit that was marked yesterday. I want to say 226. I may be wrong, Your Honor. I'll get the right nomenclature in just a second. This is one of the exhibits, one of 3 exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record? Medical records or AE's records?
It was a series of the X-rays. Yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in apple. Do you see? Have you looked at X-rays before?
I have, yes.
Have you interpreted X-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at X-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at X-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Would it be
Did you see what was going across the screen? Rex Superman's daughter says she believes her father most likely is responsible.
Appropriate to come to any opinions and conclusions in an injury analysis?
I guess for
if
more.
you were to ignore X-ray.
Alabama is preparing to execute a man with nitrogen gas.
If they existed?
It's for the 1988.
No, if X-rays exist, you need
of a woman.
to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this X-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. Dislocation, then there would be an increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these X-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B as in Bravo with the court's permission?
Yes.
Oh, sorry. I'm sorry about that. I'm sorry that you don't have.
Do you see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a X-ray. The forearm shows the ulna and the radius, which are the 2 bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not. And when you're viewing this on the software to look at the X-rays, you can actually adjust the contrast, so you can adjust the brightness. And
Yeah.
B-Tim's in the back.
Okay.
Hey, what's up?
Hey, BGM. How are
I
you?
couldn't. I want to. Do you have anyone to wish a happy birthday in a murder trial?
Yeah, was that not weird?
Oh
Like
my
creepy?
god! I was watching. I was like at work, and I was watching, like listening to Twitter, and I was listening to. When I got a break, I was listening to Grant. He's like, "Wait a minute! He wished his son happy birthday," and the judge had to. He tried to bring it up twice, and the judge had to tell
Yeah.
him like, "Move it along." And I couldn't believe it. I sat there. I'm like, "You have the grieving mother of the deceased officer in the fucking podium. Are you fucking out of your mind? This is not a civil matter. This is not like a car accident case or someone is dead, and you're talking about. I'm glad you're happy your son's alive. That lady's son's dead."
Yeah, she's sitting here watching his murderer possibly get off. Yeah.
And did you see the Post article? They posted a Post article about her where she was smiling while they were discussing the autopsy of John O'Keefe.
What? No, I missed that. Did they just?
Yeah, man, she was smiling. They have a video of it. I think that's why, like, Hank didn't want to do the rebuttal witnesses. I think he said to himself, "I don't want the jury's getting pissed," and I think, like, I don't need to bring, and I don't want to give these people an ability to kind of save themselves from this terrible situation.
And that's what it would do. So that could benefit him that way, but it also, honestly, I don't remember too many where they didn't do rebuttal. So you think it's a good thing?
No, I think it's a good. I mean, like, I think Hank is an experienced attorney. I think he played them with the whole not bringing Proctor on. I was doubtful of not bringing Proctor on. I thought it would be a bad look. And then then it showed that they had to change their whole tactic in defense because he did that. And think about this. Mr. Jackson overpromised and said that he would had an eyewitness that place him in the house, that they would prove that he was in the house, that they would prove that these were dog bites and all this stuff. And the end of the day, did he have an eyewitness that said he went in the house? No. Do they have actual proof that he ever went in the house? No.
No.
And the problem is that dog bite patterns is pseudoscience. It's just like polygraphs. It's based upon the opinions of the reader. If I showed you, it's just like if I showed you wound patterns, and I didn't say anything, and he says, "Oh, do you think it's dog bites?" You could say no, and I could go up to Miss Brittany, and she says yes. There is no scientific method in it, and that's why a lot of those objections were made about the medical examiner opining to dog bites because she never saw the body. She wasn't an expert, and even if she was an expert, it would be guessing. And I think Hank just wants to get out. I think he strongly impeached this witness. I think this witness basically showed, him talking about snowblower and basically implying that the things were planted, to me screams that he is a Karen Reed supporter, and him basically lying about the the meeting that he had. He ate lunch with the defense. He got a limo from the defense.
Huh.
He had text messages from the defense that he deleted. This shows, and also I believe that the whole situation with that rescue Randy being on the floor, but yet somehow that there's no filming of that. I think the reason why there's no filming of that is because they deleted that shit. That's what I think.
I put nothing past any of them after the shenanigans that have been pulled. The judge never did follow through with any kind of sanctions, huh?
Well, she does it after trial, I think, because
okay.
like I think the reason why is because it'd be an unfair situation for Karen Reed if suddenly like she removed counsel or did something to it. You know what I mean? Like she has to consider the rights of Karen Reed also when, just because her lawyers did something wrong doesn't mean she did something wrong. And that it would be, if she punished them during trial, could adversely affect her trial and give her an appealable issue.
That's true. Hey, honey elder. Hey, Truck You. Hey, Butter. Thank you guys for coming in. Go ahead.
What's up?
You know what this guy reminds me of? Those people that like are criminals that are on the TV show Cops, and they think they're going to be famous. And they go, look, Mom, I made it on TV. That's what he reminds me of. Like somebody that would think cops is a good way to get an acting role. This is what that guy reminds me of with the happy birthday thing.
I think the reason why is because I think Mr. Jackson told him to say that to be like more likable to the jury, and it just fell flat. It made him look really weird.
Mm-hmm.
Well,
a lot of people are agreeing though that they think that Hank, did a great. Like even Truck U saying Hank destroyed Arca. I've seen a lot of people say that Hank did good.
It depends who you talk to. If you talk to a Reed person, they say, "Well, that guy was great, and it was a strong defense. It was a strong day for the defense." I think that it was I think that was the strongest witness for the defense, and I think Hank did what he could to mitigate the damage the defense could do without a type of witness. And I think he did well. I think impeaching him, getting the guy to get flustered and angry, getting him to sound very unprofessional. I mean, I think a lot of people noticed how unprofessional this ARCA witness was, and you can tell this was not a cool collect. If you compared him to the prosecution's accident reconstruction and this guy, it's fucking night and day.
Yeah.
It's completely night and day. One guy is trying to explain the accident, explain the details, and give the answers to the questions. And when the question's not clear, he says, can you repeat it, or can you explain it, or it doesn't make sense? This guy is like, oh, there was no accident. There was no accident. Well,
he gets very hostile. He's very defiant. This that we're watching now, he gets very defiant with being cross-examined.
Oh yeah, man, it's crazy, and that's the thing that kind of turns me off about that situation, because
hey, Freddie is ready. Hey, Purple Dragon,
is that like your credibility as if you compare the ARCA witnesses from last trial to this one, they sounded a lot more neutral, they sounded more credible. But this time they sounded more like they were trying to protect their reputation, that they were trying to fight because they knew that they fucked up and they wanted to fight. And that's what it seems like. All these people who are on this trial either getting paid off, threatened, or trying to protect their own reputation. And that's what it sounds like from the defense. And it's a very desperate defense, because if you look at the defense, what did they disprove from the prosecution? 30 seconds. They're arguing with their cell phone guy that John O'Keefe, 30 seconds from the initial hit to John O'Keefe not moving. Now a garage, they're claiming. Before it was a basement, then it was upstairs, and now it's a garage.
It's a garage.
The next thing is like this woman's arguing whether he's dead or not. Well, the problem with that issue, that if he's dead in 15 minutes, is that Karen Reed's own words is that she plucked a piece of glass from his nose and blood pumped out. Guess what? Blood doesn't pump out if you're dead. Your heart still needs to be pumping. So either two things could happen in that scenario. One, she got out of her car, like Mr. Jackson stated in his opening, because he said both of them got out of their car, and then proceeded to go over to John and notice he was on the floor, fucking unconscious on the floor, and plucks the glass out and leaves him there to die, to freeze to death. Or she went there and, when uncovering from the snow, pulled the glass from his nose and he was still alive.
Yep.
Both options are not good for her, because her own statement is not going with that. And who am I going to believe? A brain surgeon or a fucking wackadoo that left 1,500 people not having autopsies and took 17 hours to get to a club fire? I don't know. I'll trust the brain surgeon.
Yeah. That's hands down. That's okay. I've been mod cheating, aka listening to Queen Now You, while also moderating on Wow. That's crazy. You're good to do that. I can't do it. Okay. We're almost, I wonder if they're going to show, I can't remember if this is the one that only shows the defense talk, or if they show the cross. With the time that's left, I don't think they're going to show the cross. I want to play the cross examination where he was very hard to deal with.
And the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229C as in Charlie. What are we looking at in this photograph?
This is the right humerus, the right upper bone of Mr. O'Keefe's right arm.
Do you notice, or did you note, did you review this in furtherance of your analysis?
I did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the, I'm sorry, the bone is the
humerus.
The humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint either.
What is your opinion and conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. O'Keefe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no indication of any type of acute injury from the x-ray to Mr. O'Keefe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back. And if we can go back to your PowerPoint. Can we go to the next slide, please?
Okay, I got ARCA expert Daniel Wolf for next.
See if I can start backing on it here.
But I want him.
Well, you say I can't hear you.
I said I got lined up to play the cross on the ARCA witness, Dr. Wolf, after this guy.
I think you're probably better off just playing the cross with this. Like, yeah, this guy.
This guy, that's the cross I want him. And I thought it was in this. His cross is.
You could probably, use, I think Yellow Cottage Shell's live streams. You could probably use theirs and just skip over their commentary and stuff like that. You know what I mean? Probably do that if you want.
Yeah.
Hello?
Yeah, I'm here. I'm listening to you.
Yeah, because I think you could jump over to like the trial, like the cross, because it was pretty contentious. At one point,
It got bad.
I mean, he was impeaching him. Like the guy's like, I didn't talk to anyone. I was in the corner eating a ham sandwich. And the guy showed, I think Hank showed him a picture. He's like, there's camera crews there, because there was a picture of him talking to Karen Reed's father after the first trial.
Yes, I remember that. Yes, there was.
No, there's a picture on Twitter. I was watching.
Yeah.
Like, this is the problem. Like, the guy's a fucking liar. So the guy was like, I was in the corner talking to, I wasn't talking to anyone. I was just in the corner, guys. And it's like, bro, what are you doing? Like, you do realize a lawyer, let me give you a clue for anyone in the chat. Whenever a lawyer asks you a question, he knows the motherfucking answer. So lying to a lawyer is a very stupid idea. Here's the photo of, here's the photo. I'll put it in the back. Here's the photo. Right there. And by the way, there's a troll going around the back, John, so don't just mind that. Here's the photo on Tuesday.
Okay, let me share. Let me share screen.
Hey, there's a troll in your
Yeah,
back.
just don't say what it says.
Don't even give him no attention.
Just ignore it.
All I was going to say was troll.
Okay.
Block it. You
know,
can't. I'll do it.
Yeah, you know the routine.
Mm-hmm.
So that guy got immediately impeached. I mean, like, you literally see him talking to Bill Reed, the father of Karen Reed, while Yannetti is being...
There they are. I remember this. Now I remember this. Yes.
And there's another photo of him eating lunch with Bill Reed.
Yeah. I remember. Yes. Yeah, he did.
So that's
pictures are right there. I mean, they're clearly having a conversation.
Yeah, and there was supposed to be a sequestration order. There was supposed to be like, you're not supposed to have a conversation with the ARCA witnesses, with the prosecution or the defense, and they were supposed to be neutral. And here he is having a conversation with Bill Reed.
Yeah. Do you think that the clips that they were able to show of Karen Reed's own statements, what do you think the jury's gonna?
I mean, it depends if the jury is like, if the jury trusts the scientific evidence by the I think the prosecution will get a conviction. If they don't, then I think you're probably going to look at a hung jury. I don't think there's a chance of an acquittal. If they didn't acquit,
I don't think it would be acquittal. Do you think do you think there's a strong possibility of a hung jury?
I think there's always a possibility. I mean, the problem is the X factor is I don't know if a Karen Reed person has gotten to the jury. And I don't know, because you have to realize this whole fucking town has been infected by this case.
Right.
So, I mean, I don't know. I don't know. If it was just neutral people hearing this case, I would be like, yeah, she's a 85 to 90% chance again convicted.
Is that you, Britt?
Yes, sorry, I booted.
No, that's okay. I just want to make sure it's you because, people like to come in.
I would be like 85 to 90% chance that she's getting convicted. But since I don't know, I think there's probably, I have to see the closing, and I have to see if there's going to be like a charging of criminal intent. So, you know what I mean? Like,
Yeah, that's a good one. I didn't even think of the closings should be interesting.
I think
they have to be.
I mean, listen, I think the problem with Jackson is he promised all these things in the beginning and he didn't deliver. He didn't deliver.
No.
All his witnesses, to me, if I was on a jury, these would be paid shills.
Yeah, that some of the witnesses, in my opinion, some of the witness testimony hurt them, not help them.
Yeah, I mean, most of them were sounding like they were threatened or they were paid shills. You know what I mean?
Right. Hey, Lucia. Yeah. Hey, Brianna. I seen you come in. Sorry, I didn't get to. I have a feeling he got his ass reamed for admitting shit on the stand last time, and I agree with B. Tim. Arca is fighting for their pride, not justice. Good point.
Yeah,
but this is the cross of this guy, the guy we were just watching.
Yeah, and
that was the defense is doing their questioning. This is the cross. This is where it got hairy.
Yeah, and I think honestly, I don't know why Jackson thought it was a great idea to be smiling and joking and all this stuff. And it's like the mother of the individual that was murdered is in the courtroom. This is not like a car accident case where I'm claiming injuries, or this is a murder trial. You should not be saying happy birthday. And Canone honestly was very light on him, because there were other judges that would have threw him out of the fucking courtroom for that, because he was warned once and then he did it again, and he was warned twice. And any law tuber that says otherwise, you're a fucking idiot. A judge would have flipped his fucking head if he would have seen this happen in their courtroom, because that is so disrespectful to the court. It's disrespectful to the victim's family, who is sitting over there, who's been there for 2 trials, years waiting for this case. And people are like, why is Hank so angry? It's called righteous indignation of a corrupt piece of shit, garbage human being that is lying to save his reputation and for money. And when you're dealing with people like that, you got to show them for who they are. And you got to fight for the victims. And the victims is John O'Keefe's fucking family. Those are the victims of this situation. Not Karen Reed, not the fucking carefree Karen Reed people. It's John O'Keefe's family. And he's fighting so that those people can get justice after almost 3 years of fucking bullshit.
Like I said, they could have probably pled this down. She could have already been out and moved on with her life, I don't know. This is just crazy.
Well, I think the reason why there's 14 sidebars is because Hank was like,
"Hey, Summer Girl, good to see you."
Hey, Summer Girl. Was basically putting in the screws. But you can play it and I'll keep quiet.
Okay, let's go. Now this
I would play at 2 times speed though, or 1.5 speed.
this guy gets really let's try it here. I don't know if 1.5 might be too fast. This guy here is
Hey, Kathy, before you start that, Freddie's in the back.
okay. Hey, Freddie. The camera's on, dear. I didn't know if you wanted it on. Just wanted to let you know.
I was just proving it was me. I wanted you to know I have a different account for my thing because my computer went kaput.
Oh, dear.
So I am now, Freddie is ready. I have the other one, but that one don't have a camera, so I have to use this one now. I just wanted to come up and tell you that so that you guys didn't call me a troll.
I kind of figured that's who it was. I just didn't know if you wanted it called, if you wanted me to say anything.
It's fine. I was gonna wrap myself anyway. I'm not incognito here. You know I'm an a-hole. I had to ask a question. Did anybody think that those scratches on that arm, that picture we were seeing, did that look like glass cut his arm?
Well, I think it's a combination of abrasions or possibly taillight, to be honest with you. I think that the issue with the defense is that even their own defense witnesses said they were abrasions and they were not puncture wounds. What was very interesting is that Dr. Russell said that they were abrasions, I believe. She didn't say puncture wounds. She opined scratches and stuff like that. And then the medical examiner who says, I find out due to the body, which she never actually looked at the body. She looked at pictures, says they're punctures, but they were not punctures. And if there are bites, you would expect punctures. It's to be expected from a dog.
You would
bite.
expect to see teeth because I can show you my leg where I was bit by a dog, and
and you would notice like they were puncture wounds, right?
Right. Yeah. Oh, and he took a chunk out of my leg, so that's not at all what that looked like.
I mean, and that's the issue, and that's the problem with a lot of people. They look at these things, and if I basically tell you what I think they are, your brain tries to assimilate it and kind of convert that into what I told you. It's just like those spirit boxes, or just like images. If I show you an image and I tell you what it is, your brain tries to make sense of it. And it's the same thing with dog bites, and that's why it's not a science. That honestly, I think the judge made a mistake allowing Dr. Russell, to come in due to the fact that she didn't have any scientific method that another expert could use to come to the same conclusion.
Yeah,
there's a couple comments here. Twisted Tragedy showed a video with one piece of tail light, and the end was the exact same as one of the cuts.
That's true. That's true. And it's just, I think that the problem is with the defense is that even their own defense witnesses are conflicting with each other. One says abrasion, one says scratches, one says puncture wounds, when the ME didn't say puncture wounds.
Yeah, I think they all should.
Summer Girl says, what about the crap Hank pulled?
What do you mean the crap Hank pulled? Which one? Do you mean like the statements he was like kind of making like slide statements?
Oh no, you're not, Summer Girl. You're welcome here. We're just having a discussion and playing the court videos. But there's people think she's innocent. That's fine. No, that's fine.
I think if you're talking about the holes in the sweater situation, that was a bad mistake. I don't think he intentionally did that, because no lawyer would ever want to sound like to the jury that they made a mistake. And I think the mistake from the defense is they should have capitalized that on, and I hope they might capitalize it in their closing, because that was a kind of a gift to the defense, actually, that moment when he mislabeled the what the criminologist or whatever removed those holes.
Sorry, I quit lighting my lighter.
That's fine.
I put it away.
The criminologist, cut those holes in, and it was actually, and he thought that there was like from the scene. So I mean, and there was an instruction given, but it's actually a gift to the defense, and they can use that for their closing or something like that, saying, look, they're so disorganized, they don't even know what is the actual done by the police and what is done here, and you can't convict my client because
there's always crap done on both sides during a high profile trial like this. But at the end of the day, the jury's the ones who are going to make that decision. I
Oh.
have no idea which way they're going to go. I just don't see them finding her not guilty.
You know what? I'm shocked. The X-rays was a shocking thing. I was actually shocked
Yeah.
that not even the defense brought up the X-rays in the first trial. So no one brought up the X-rays for the first trial. In the second trial, the defense brings it up. I think though the problem is that I've seen many car accidents where not a bone was broken, and it's just a lot of soft tissue injuries, and it happens all the
That would
time.
have been me.
No, I mean I've seen it a lot.
Yeah.
I mean I can tell you I can't. I'm not going to dox myself, but I can tell you for the past 5 years I've seen about 1,000 car accidents. I'd probably say, and I know that there are some people that get hit by cars. Bones don't break all the time. What happens is a lot of soft tissue damage. The disc get out of place. Muscle. Things like that. You don't break bones. There are no. There's
spine and
stuff. There's no frac. You know what I mean? So it wasn't really surprising for me to hear like, oh my God, he put his arm up and his arm didn't break. I mean, like, yeah, that's not really shocking to me because I've seen that happen before.
If he got hit by a car, how fast are they saying that car was going?
24 point something miles an hour backwards.
That's not enough for all that.
Or anyone in here? Do you watch Duty Run? Duty Run. I mean, like, I respect Duty Run, but I disagree with his opinions on this case. I don't think I honestly think Duty Run is not. I think the lawyer is he's just saying it for the audience. I think though that Duty Ron is kind of I think he's right about the initial start of this case where there was definitely things that should have been done and that were not done. And I think that the defense has taken advantage of it really well. For instance, a solo cup. I think before I used to, think it wasn't too bad of an idea. Then I got a book on the FBI procedures of evidence collection and realized, oh shit, you're not supposed to collect anything in plastic because it degrades the DNA badly. And also another issue is that it's not really, they should have had it glass. They should have had sealed. They shouldn't have not put it next to the car while they were taking pictures. They should have probably the moment that Karen Reed started saying, I hit him, they should have taken her to the station. They should have taken everyone to the station, to be completely honest with you, and questioned.
There was definitely mistakes made. The ball dropped, definitely.
So, I mean, I think that's the issue. And I think because of that, there was a lot of people that mixed incompetence with a conspiracy. Now,
True.
So, you know what I mean? And I think that the incompetence is from the initial officers making mistakes that they should not have made. But the facts are the facts. And you can tell by looking at this trial that there is cell phone data. And now the defense has not refuted the cell phone data. That is a big problem. They have not refuted the temperature drop of the cell phone data. They haven't refuted the fact that there's over 11 people that did not see this man go in that house. There is no cell phone data that shows he went in that house. They try to say he made 36 steps, but the facts are that cell phone data doesn't show that it was moved. And the reason why they had to change from the basement to the garage is because the 30 whatever the steps went to the garage, could go to the garage, in their estimation. But the facts are the facts, and the cell phone data, I believe, is the most damning.
Yeah, usually cell phone.
And Ron, you're right. Drunk drivers walk away from horrific accidents. My son's best friend since they were 9 years old. And they only lived right up the street, but they grew up together. Him and his brother.
Well,
and another guy was in a horrific accident. They were hit by a drunk driver who didn't even have a license. He was on suspension. He had multiple DUIs. He was so drunk, he didn't know that he hit a big white van. Both the brothers died. The third guy was seriously injured, but thankfully he pulled through. Both the brothers suffered.
Yeah.
And he didn't know he hit anybody, didn't have a scratch on him.
Yeah. I mean, at the end of the day, I just think the problem is the defense, I think, focused way too much on dog bites, and they didn't focus on a timeline to establish the jury to actually go into the theory of the defense. okay, let's say we believe that the conspiracy, right? There is no timeline that allows for planting of evidence. He hasn't explained it. They haven't explained a perfect timeline for which.
Yeah, see, I can't get past the data. The data shows that John did not enter that house. The data shows that she hit him.
There's also the issue of her statements. Her statements are incriminating. They are very incriminating, especially the statement where she asked Giannetti, "What if I backed into him and rolled over his leg?" And he.
You're right. They all had alcohol in their systems, Truckee. They were all partying. You're right. John did too.
Yeah.
They brought the Proctor text in, but didn't pursue it. Okay, let's get into this guy's testimony because this is the cross. It's supposed to be the cross, the full cross. So hopefully it is.
Matter, don't they?
They do, yes, sir.
You said it many, many times. Facts matter. Isn't that correct?
Now, this is
details, but facts matter too.
This is the prosecution. This is Hank cross-examining. Another. He's considered one of the ARCA witnesses, isn't he?
Yes.
Details matter, Doctor?
They do.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately. We don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
You, excuse me, sir.
So go ahead and ask the question.
Dr. Rentschler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
Play exhibit 2, please. When you were giving your estimate, 10 to 20 feet, Dr. Rentschler. Did you ever see this photograph before or part of this video?
I'm sure I have.
When you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before?
Yes.
And when you look at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure, yes.
Sure?
Yes.
20 feet, Dr. Rentschler?
The way I explained it to you, yes, sir. 10 to 20 feet.
Details matter, don't they?
They certainly do, yes, sir.
Take that down, please. Did you speak to anybody today, before you testified, about Dr. Welch's testimony in court?
I did not today, no, sir.
Before today, did you speak to anybody about Dr. Welch's testimony?
I did not, no, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so, no, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did, yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know the 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight for Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights,
good point.
It would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the hybrid 3, and I use a hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any conclusions, or did you know that when Dr. Wolf did his tests using the hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration. The acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio of force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it with anybody, you said?
I did not know.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us, told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything. But yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer
He's
about
getting uptight.
details of this case, weren't you?
Yes, Your Honor. Maybe a question.
Maybe we can approach briefly.
About other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Did you testify under oath that they did inform you, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
You can see with every question how he's starting to. You can.
Well, yeah, because he knows that he broke the sequestration order. If you don't know, he's not supposed. When you're on a sequestration order, you're not supposed to talk about the case while you're testifying. You're not supposed to watch things in the case. And he's breaking, and he's getting play-by-play information. Right. And you've seen with the last witness, which was Russell, that she was literally broke the sequestration order the next day because she went into a limousine and talked to Alessi and got legal advice on how to handle questions from Hank Brennan. So, and breaking a sequestration order is a big no-no in the legal system. And it could be like you could be hit with fines. You can possibly do jail time. It's not it's not a good situation to do. You know,
wouldn't it be considered contempt of court for not listening?
Yeah.
To the rules?
And also it destroys your reputation as a professional agency because you've shown that you're willing to break the rules. I mean, you're not neutral. I mean, like at the end of the day, you are a hired gun. There is no one neutral here. A prosecution witness is for the prosecution. Defense witness for a defense, but there are rules that you follow. You know, it's like a chess game. Everyone follows the rules, but if one side keeps on breaking the rules, it's not good.
No.
And could this potentially get the case thrown out of court?
No, I don't think the case gets thrown out of court. Mm-hmm. What's going to happen is that you might see sanctions coming after people afterwards because you have to realize. You have to take into account Karen Reed's rights. You know, just because our lawyers are dirtbags, should she be fucking punished and, sent to jail wrongfully because of that? You know what I mean? Like, and when I say wrongfully, I mean like, unduly prejudiced because of her lawyer's stupidity. You know what I mean?
Yeah.
She's deserving of a fair trial. Even if you don't like her, she's deserving of a fair trial. Mm-hmm. So that's how it goes.
Yeah.
Thank you, B. Tim.
Would you agree it certainly helped you prepare?
It helped me prepare?
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all, no. It doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that information certainly helped you prepare?
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific answer.
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter. So let's talk about details.
Sure.
You're denying that receiving that information certainly helped you prepare. You're denying it.
I'm going to allow it.
Yeah, I don't think that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question. Receiving that information from your employer, are you denying it helped you understand what was going on during the trial?
I'm going to allow that.
I don't even think that it did. I don't understand it. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. It doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yes, there was one right before my qualification, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
So you don't believe?
No, there was no need to.
That's not the question. Details matter. Was there any attempt?
So the objection's sustained. I'm going to strike that, folks, okay? Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
There's no sound. Just stopped. Kathy?
I'm here. I agree with you guys' comments in chat. I don't think Proctor was dirty. I just don't think that he cared for Karen. What little,
Yeah,
I just don't think he cared for her. And that just, what happened with John and everything that transpired just pushed that even over the edge more. And some of his feelings may have come out, but I don't believe he messed with any evidence, and I don't believe he's dirty.
Yeah, I think he basically, it was like a friends group from high school. I think he talked about multiple cases, probably multiple situations. But I think that was just how he did. And this was probably a pretty big event, and it's just,
small town, how
is it professional? Yeah, is it professional?
Went over by his drunk girlfriend, come on.
Yeah, is it professional? No. Is it smart? No. Do I think he deserves to be fired? I mean, it's debatable. I don't know. I think that's a little bit too much. But in the end of the day, I don't think he's corrupt. I didn't see any evidence showing that he planted anything. I didn't see any of that. And the defense had 2 trials and opportunities to show that, and they have not shown that. I think in the end, that's just my opinion.
Hey, 2-year-olds are running the world. My theory. John was having an affair with his friend's wife. Karen was drunk and there. His friend and he started fighting. Dog got agitated and in the middle somehow. Homeowner threw them out.
Well, the problem with that theory is...
So then you think that Karen was actually in the house too. And they got thrown out and continued their argument outside, and that's what happened?
No, that might be what he's thinking, but the issue is the reason why the dog was brought in.
They have the data to show that John never entered the house.
Yeah, he never entered the house. But the original reason why they brought the dog in was because of Cullen. The idea was that the original theory of the defense was Cullen was, didn't like John because John was a nemocracker, a guy that didn't like people on his lawn. And they lured him there, and Cullen beat up this 6'2" man, 6'1" man, and knocked him out. And they put him in the basement, and then they put him in the car later on. They dropped him off there and all that stuff. And the dog was defending Cullen. That was the whole theory back then.
There was no disruption in the snow. For them to do that, there would have been disruption all through the snow.
Yeah, that makes a difference.
Yeah, and the problem is that
Nathan,
the cell phone data, because this issue is that the temperature lowers, and a garage would not have lowered that temp, even if he was in the garage, which there's no evidence showing that. They're just moving it there because they're throwing everything at the wall for an acquittal. And I think like a very telling situation. If I was on a jury, I would look at Karen Reed's facial structures. And when you're smiling, when they're talking about an autopsy of your ex-boyfriend of 2 years, and you're joking, that's a problem. That's a huge fucking problem. And her facial reactions are bad. And then they see her statements.
And I get that it's her, it's stressful. She's on trial for her life and all that. But
I
don't think I'd be smiling and laughing.
Can I share my screen? Can I share my screen? I'm going to show you what they showed here. Let me see. This is from the Post. This is what she was doing while they were discussing the autopsy of her ex. I haven't.
Wait a minute. All right. There we go.
You see?
Yeah. Yeah.
Do you realize
And
this is about
them out drinking and stuff? Isn't he a married man? It's just, and the way they touch on each other,
but
that's
like,
inappropriate.
Like if I was on a jury and I seen the defendant do this smile while they're discussing cutting open her boyfriend in an autopsy.
Yeah, even a couple of years later, you're still going to be. I mean, I'm sure she probably hates them all, but still, as a human, that would. She seems very happy and jovial there when they're talking about. Yeah, that's
little inappropriate.
He's very cold. She's a very cold. That's why you can just, if she's drinking heavy and they were drinking liquor, not beer, and sometimes liquor can, bring out the best in you, as they say. She just seems like you piss her off when she's really drunk, and she could be pretty evil.
Ratchet.
And I don't think she even needs to be drunk.
But
I don't know. There's been some inappropriateness. I mean, I don't know. A client and their attorney shouldn't be hanging on each other the way they do and always out together. It's just weird. And they're always out afterwards. And I don't know. It's just weird. And drinking, nonetheless. It's just weird. Maybe I'm making too much out of it.
No, I agree.
Right. I think they were already planning. That was already in the works, from what I understand, about the dog. Tim, is that correct? That wasn't just a spur of the moment decision.
I think he dropped down.
Oh. Maybe he'll come back. He must have, I'll watch for him in the back. Yeah, I don't think. And I think the house had already been in the works too. DC's Granny. Goodness. Aries, I love your new name. DC's Granny's Goodness. It's good to see you, Aries. Good to see you. Hey, Kenna. Thanks, guys. Tim must have something happened. I don't know. He was. Maybe he'll come back. Yeah, like Casey Anthony. Yeah. The private investigator. Yeah. And the older lawyer that she ended up living with for years down here, Yeah. This.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took the ride. If I wanted to appear independent, then I would have taken an Uber.
Have a conversation about that you were thinking about taking an Uber.
It didn't even cross my mind, sir.
And then after you testified, did you say independent?
What do you mean independent?
Well, did you have any bias for any of it?
Any bias?
Bias.
Thanks, guys.
What do you mean? Did I have any bias?
After you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people, and so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride.
You think the Orca Andy wasn't as bad the first trial? I think AJ got to him and put the pressure on. Yeah, he got really, he gets kind of defiant in my opinion. I mean, he just seems to have a real bad chip and a real bad attitude, and you could see it escalating, his mood escalating. And you can see it in his expressions, in his eyes. I love your new name, Aries.
We'll take you to the airport. So I went, and I had a ham sandwich.
Had a ham sandwich. Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I just sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, he's really
Certainly, I did, sir.
Did you laugh along?
Tapping
I
around
assume
it.
if something funny was said, I probably laughed.
Did you talk about your testimony?
I don't, at this point, I don't even remember.
Let me alert you of something. When you were there at the luncheon, did you see a camera crew?
I believe I did, yes, sir.
Filming and documenting, right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case and your answers and laughing it up a little bit?
I have no idea, possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Sure.
You
He's
have
really
conversations with
getting
some of these
fired
folks.
up here.
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue what we would have talked about.
Do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea. I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
You remember when you were...
Because it had to do with a trial that you're an expert witness in, maybe?
Yeah, I mean, like if I was a person that was to accept this, I mean, like how he's being cagey about this screams a lot of problems. This shows a weird, like I would be sitting there, I'd be like, no, I'm not. I just jumped off because I just had that issue with the power. So my computer shut off for some reason. His caginess is a problem. You know what I mean?
And he's escalating.
Yeah, and you can just tell, like he's handling it very badly. And he's like, "I can't even remember last week," and that's not a smart way to go. As an expert, you know what I mean? Why would you be so cagey about what you having for lunch and who you're having for lunch with?
I agree with Darby.
You could tell he's nervous about something and he's trying. And if he knew camera crews are there and he's arrogant about it, he knew the chances are he was standing there having a conversation with the gentleman. That's clear as can be.
Yeah, there's actually a picture. I showed that picture, and there's him.
Yeah, it's on the top.
Yeah, and he shows it to him. He shows him that picture.
I agree with Darby. Guilty conscience, and his whole body language on that stand is somebody not sure of what he's doing.
Yeah, I think what happened, and this is my opinion, I think they initially did a very short, easy contract for the federal government, $25,000. I mean, I don't know how much they were paid. I think they were paid like a bunch of money. Not a lot, but they were paid. They were told to shoot a cocktail glass at it, and they did a half-assed job. And then they were called into question about their work, and then they had to double down when Jackson came to them, you know. Mm-hmm. And they basically made sure to pick the best data that was obscure. And the situation is that they're claiming that this is no accident or anything like that. But the fact is, how could you claim it's not an accident if you can't reproduce the results? Like if you don't know where he was standing, you don't know what he was doing, you don't know nothing. All you're really doing is speculating, and that's what he's doing. They basically put a dummy up there, and they're speculating, and they're you know, and that's pretty much it. But in the end of the day, that taillight shattered with their own test, even their own ridiculous test, and that's pretty a bad situation in my opinion. It was a disastrous situation to do that, and they know it, and their reputation is going to look like dog shit because of that.
Should. All right, let's get back into. He's getting really
shit.
Having conversations with some of these folks, and you were laughing about when the prosecutor asked you about other evidence like DNA. You had a response about the physics doesn't change. Remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there enjoying the event? How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, you got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back to the airport, ultimately your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
Well, you wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down, and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
And then I have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep it going?
I enter my billing every week, yes.
Do you know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCA. I have no idea how much ARCA's been paid.
How much has ARCA been paid because of your work so far?
Yeah, the FBI did hire them.
Yeah, they got information from the defense. They never asked to request information from the prosecution. So all the information they got was basically, limited data. Mm-hmm. And they weren't informed about the hair in the back of the taillight. They weren't informed about, the cocktail glass on the bumper, or the glass on the bumper, or the cocktail glass at the scene. They weren't even really informed about, I think they weren't even informed about taillight pieces around, or a shoe, or something like that. They really weren't informed about a lot about the accident. And that's a big problem, because if you're an accident reconstructionist, everything in the location of the accident is evidence, is basically helps you figure out what happened. And he talks about science, but the scientific method is to basically grab everything, and then when you grab all the information, then you try to reproduce the results or try to eliminate the variables. And the problem is that he did not want to accept the shoe, the hat, the taillight pieces, the cocktail glass, the straw at the scene. He did not want to accept the fact of the tech stream data showing that the car goes back a certain amount, feet 24 miles an hour. He did not want to accept any of that, which would have been essential for figuring out if an accident occurred. Instead, he wants to adhere to an even less theory. I mean, okay, let's say we don't believe it's an accident. Can we reproduce the results of a dog bite like that? Can we reproduce the results of a man just falling, somehow gets slightly scratched by a dog or bitten or whatever, like light teeth are scratching against his skin, and he falls right on his head and dies 15 minutes later with no one else punching him or pushing him or breaking any other bones? I mean, for a person who's actually been in a fight, I can tell you that you will get bruised somewhere. That's what I think.
Sorry, Jabba Jones. That was I was tapping it. I was going to type A. Sorry about that. I unhid you right away. Sorry. The body told the story. John wasn't hit by a car.
The problem
so
is
you believe that he wasn't either? Okay.
The problem with the whole body tells the story, what the lady said, is she never saw the body.
Right.
She saw pictures and she saw medical reports, and she's disregarding the findings of the medical examiner and she's opining to her own theory, and she's not really following up with actual science. And that's the problem. And unfortunately, she has a history of doing that for a lot of situations.
Yeah, she does.
So
yeah.
It is what it is. You keep it going.
I have no idea. I'm not involved in financials, sir.
You have no idea how much time, how much compensation your company's going to get for the work that you've done and continue to do on this case. You have no idea.
It's not my concern. It's not my department, so I don't.
That's a no?
That's a no.
I don't believe that.
When you communicated with the defense, you texted, didn't you?
When?
At any point.
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
But when you say you believe so, details matter. Yeah. Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with whatever I had.
Did you have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
When you say probably, did you delete the text that you had with the defense?
Only those 2?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
So stop.
I did not, no, sir.
What?
So we're everyone shit on Higgins, and people deleting their text after you have Higgins getting rid of his cell phone, whatever, and all that stuff. But yet these 2 guys simultaneously delete all their text with the defense witness, and no one finds that odd.
I do.
Yeah, simultaneous. It's not one guy and the other guy just whatever. And you have to realize experts are paid for their time like this, and those texts would actually be saved for 7 years. You have to save that information for basically for when it could be subpoenaed later, just like transcripts and other things like that. So the fact that they both simultaneously deleted their text is very sketchy, especially when you just find out it's a hung jury and there's going to be another trial. Why would you delete your text when these are going to be your future customers in the future?
And don't they know that those text messages can still be found if they wanted to find them?
Well, you'd have to, I don't know how that process would go.
It's difficult.
I just don't. But at the end of the day, that sounds sketchy. And his evasiveness is not good.
Oh, this stupid thing won't shut off. Okay, sorry about that.
But you keep on playing. I just think his evasiveness is not good. It's You don't need to like be sketchy about it. You know what I mean? But when both of you deleted the same day, it's not a good sign. It doesn't look good.
Right. All right.
I have no need to.
Why would you have a need to?
I'm going to allow it.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
It's for, I think, for encrypted messages.
Do any of your colleagues use Signal to have conversations with their clients?
I'm going to allow that you're aware.
I have no idea what my fellow employees or cohorts do.
One of your fellow employees is a gentleman by the name of Dr. Wolf. Yeah, you worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
I'm going to allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
When you worked on this case, when you began, you worked with a gentleman by the name of Mr. Klein?
Scott Klein is another engineer at ARCA that worked on the case, correct.
And you worked with Dr. Wolf?
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf are in the Philadelphia office, so we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you would do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that?
Sustained.
Let me ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted?
Sustained.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You, though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
I mean, there was budgets, and we had to stay within certain values, so I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Can anybody tell you what tests you could or couldn't do?
That didn't sound too good either. So I didn't get to do whatever I wanted because he didn't have free reign either. So is he saying maybe there was other things he would have done? Listen to that helicopter. Wow. Slow.
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions
What
denied?
do you mean you're assuming?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
So without that, Priya, go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up
So
or not.
basically, the defense paid his firm a good deal of money,
$70,000.
gave them the info they wanted them to have to come up with this.
Well, they told him
the
exactly.
story they wanted them to come up. They basically controlled the narrative.
They basically told him, we want you to do this test for this amount of money, and we don't. We want to curtail to like this, and that's what Mr.
This
Hank
is what we wanted to show. So that's what he's showing. He didn't bother to consider anything else.
Yeah, and that's what Hank is getting at. He started off showing his bias, and then he's going to undercut his professionalism by saying, well, you wrote articles about wheelchair accessibility 20 years ago. This is why Hank is very good at cross, because he's cutting down this guy into pieces.
Yeah, I mean,
and he's and normally this is a very qualified. I'm not saying these ARCA witnesses aren't qualified. I think they're both very smart men, but they are clearly biased and they're clearly have an agenda, and it's very tough to unpeel that agenda. And I think Hank is doing a very good job, because I don't think any other lawyer could have done as good a job as he has done in this case. I think they would have been overwhelmed by this, to be honest with you.
Exactly, runs with scissors, not within budget, but he claims he didn't know how much they were paid.
Yeah, and that's
he knew every penny.
He seems to be double talking himself all the time.
Yeah, he's making himself look. He's losing credibility.
Is he looking like a Karen?
All right, let's go.
Not.
Do you, since your memory is difficult,
Sustained. Okay.
Your
to
memory
remember
is
things, you
difficult.
write them down.
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
You provided a CV, which is a resume?
That's correct, yes.
Resume outlines your education,
Yes, sir.
areas of specialty,
Correct.
and then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer reviewed.
Correct.
And peer review publications mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003. Is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school. Correct.
Have you had any peer-review articles since 2003?
Probably not, no.
And your peer-review articles, 2003, deal with the evaluation of selected electric-powered wheelchairs?
That was one of them, yes, sir.
The next one, intelligent walkers for the elderly?
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs?
Yes, sir.
Evaluation of a pushroom activated power-assisted wheelchair?
Correct.
Displacement between the seating surface and hybrid, testing dummy during transitions with a variable configuration wheelchair?
The hybrid 3, yes, sir.
Assessment of manual wheelchair ride?
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross-brace designs?
Yes, sir.
Evaluation of selected ultralight manual wheelchairs?
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass?
Yes, sir.
Okay. And so you would agree that all of your peer review articles deal with wheelchairs?
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
Do any of them deal with pedestrian collisions?
No, they don't.
You've written a book chapter?
That's a good
Yes, sir.
question.
Smart technology?
Yeah, that was
Yes, sir.
all these papers and books and stuff, and nothing was about.
Yeah, and this is what like you have to listen to. It's like people say, "Well, he did a great job, this guy." And I'm like, I don't think they listen. I think they mostly like do cheerleading and don't realize they're not paying attention
Or
to
cherry
what Brennan-
pick.
Yeah,
They
what
cherry
Brennan's
pick.
doing. First, he showed that he's biased. Second, that he's a liar. Third, that he's not qualified for accidents because he's writing peer review for wheelchairs. Fourth, that he is, just basically he's implying that he's, doing what he's paid to do. And that's going to lead up to other things. And I think the most damning part about this guy, he talks about, what do you mean the taillight removed with the leaf blower? To me, was kind of wild for him to state that line, because that to me is like, what are you doing, sir? Like, you're not, you know what I mean? That's not a good thing to do. You have to keep your calm when you're an expert. It's not good. You know what I mean?
He's losing credibility with every question. It's really making me doubt every question that he boxes around and jabs around. It's just making me doubt his testimony. That's a lot of money. What's the CW channel?
It is a lot of money. I mean, I think the prosecution's accident reconstruction person, they had to spend a lot of money to basically all the data points and everything they had to go with. Listen, be an expert, make a bunch of money. That's what I say.
Oh, no, Summer Girl, we weren't meaning you. We were just meaning in general. And a lot of people do that. They'll fast forward through things and just cherry pick certain things out. Or while they're listening, they're only listening to hear what they think are the good points.
Yeah, I was referring to a lot of people because I watch Twitter and there's a lot of people who just don't understand the points. They're not listening. And even lawyers, I've noticed like the lawyer, that's like, I think he's got a love affair with with that other Betero or something like that. Yeah. I think they're like gonna.
Twitter is crazy.
Yeah,
I mean, you should see the files of a Twitter post that I have just concerning the TurtleBoy side of it, and Karen Reed's, of course, in all that. But it's hard to even keep up with.
Yeah, I just think like you gotta really pay attention to what he's setting up. And now, will the jury? Now, the most important thing is, will the jury pick this up? Will the jury see?
Wait a minute, Navin, I'll get you.
All right. Will the
but
jury?
I got to put up my screen.
Okay, no problem.
No, Navin wants to come up. Please don't. Just be respectful is all I ask.
Okay, I'm going to yell at that person.
Hey.
I'm totally fine.
Okay.
Nothing
Oh,
bad.
you know him, beat him? I can take the screen down?
No,
No,
yeah,
I
you
don't-
can take it down. You don't. I know you can't be too careful these days, but you can leave it up or you can take it down. Whatever you want to do, that's
If we
fine.
see a little lemon something, we're not going to like it. You know, there's been lemons flying around.
Yeah.
No flying lemon. No flying lemons.
All right, what's your
Okay.
thoughts on this case?
I'm gonna mute. B Tim's on fire.
All right, so check this out. I want to get your feedback on this. So we all saw Welcher's. We don't need to go over that. We saw his experiment with paint and to show them how everything kind of lines up geometrically.
Yeah.
With this guy, I'll call him Andy because his last name evades me. Okay, you notice? Okay, no, he has the arm.
Welcher.
He has the arm straight out. Now nobody holds a glass with the arms straight out. Nobody walks around like that. That's crazy. Nobody walks around, with the glass straight out, with their arms straight out. So, and even if they don't have glass, 9 times nobody really walks around with their hands straight out to like they're zombies. So
right.
So typically you have your arm. Most people look at their arm right now. It's probably their upper arm is kind of more parallel with their body, and the right arm, if they're holding the phone with their forearm, is kind of sticking out a little bit. Right? That's normal. That's natural. So here's what I'm getting at. They're about the broken bones. Now I don't really care that there isn't any broken bones. Doesn't bother me too much because I've seen people get hit, not broke bones. You talked about that. But if the upper arm was away from the body a little bit and parallel with the body, but away, okay, and it got hit first, you have that initial impact right on the arm against the taillight, and that compromised the taillight, cracked it, compromised it, whatever. And then everything went towards his body. Now we know what that means. More mass, right? Which is going to increase force because more mass. It's in Newton's second law. The body becomes, now it's not just the weight of the arm, it's the body now. So it's like a boom, boom. It's like an initial hit, and then right after that, arm goes through the body, and then there's a forced resistance by the heavier mass, the body, that shatters the taillight, and so that's kind of what I'm getting at is I don't need this guy to say, well, there's no bruising, there's no broken bones, so it can't be. Well, I'm sorry, I think it could be that there was initial like a shock absorber. I think the first part. Go ahead.
I think the reason why he might have had his arm bent like that or done like that is because what do you do if I try to punch you in the stomach? You guard your stomach, right? There's like a natural reaction. So imagine like last minute you see a car, sideswiping or whatnot. What do? You try to guard your vital parts of your body. And that's what I think maybe happened with the taillight. And I think that was the situation.
It could have been. But I think I'm thinking that naturally there's probably 2 impacts, one followed by the other, almost in milliseconds, but just enough where the taillight was the arm didn't take all of the force. Is what I'm saying.
I mean,
it took the initial force to crack the taillight, and then it went into the body, and the rest of the body, and that's why because there's 2 impacts. It splits the force. I don't know what the ratio would be, but there was initial hit, and then the body. More mass would create more force against the taillight, and that would keep his arm from being broken. It's kind of like when you break your fall, kind of thing.
I kind of think that could be it, but we don't really know what the position of the position of John was when the car backed in, and that's one of the reasons why the prosecution's accident reconstruction didn't do a test like that the defense did, because that would be purely speculative. And Jackson would have torn him into ribbons, because Jackson's an experienced cross-examiner. He's not good at direct, but he could if he would have done the same thing as Arca and did the same type of test, he would have tore him a new asshole, because that would be pure speculation. You wouldn't know. Yeah.
Is that, and also I think I'm just my feeling, and listening to everybody, that Welcher and Aperture are more intellectually honest. And they knew full well they couldn't do a force analysis because too many variables were unknown. And he came out and said that. I mean, so, that's rather than try to pull the wool over people's eyes with that, especially the wolf guy, with that little sheepish grin, I just got the feeling it was like, I'm being lied to here, I'm being. Anyway,
I try not to rock the boat. No, it's fine, Summer Girl. You can state your opinions about the case. I think Petty's kind of with you.
Here comes the lemons. Watch out.
No. Lemons is another lemon. That's not about free carrying people. But yeah, the whole idea is that I think that's the reason why the prosecution didn't want him to do accident reconstruction like the ones they did or attempted to do. Because
hey, Petty, that's Craig.
yeah. Oh no, it's Greg. I'm joking. That's joking.
No, this guy actually can talk and has
Yeah,
legit.
he has
yeah.
and he's not into 80-year-old women, 90-year-old women. Are you into 90-year-old women?
With lingerie, beat him. Come on.
Yeah, that's true. That's true.
That's not. It's his first time here. Let's not make him.
Oh, y'all were talking to me?
Yeah, we were talking
yeah. Somebody was saying that you actually have more. They were asking.
There was a guy that got caught, in the community that
Hey, Melinda.
basically
Petty.
he had Instagram and he
I know, Petty. You're giving us a laugh.
And he basically had his follows public, and basically he was following, and this is like a 30-something-year-old man, and he was following all like 70-year-old women who were in lingerie, and
okay,
and 80-year-old women, and very voluptuous women. Let's just say that.
That's not normal. Those two words shouldn't go together. I'm sorry. 90-year-old women and voluptuous. Well,
Yeah.
It was just a joke. I wasn't nothing serious.
All right, well,
But you could put thoughts together, and you know what you're talking about.
well, thanks for the nightmares. Appreciate that.
I'm over 50, so I decided not to put a picture up.
Yeah.
No, we don't need to see any more 80-year-old.
Yeah, I seen it. That was gross.
There was a lot of lugs. I was like,
And I'm 61, but I just, yeah, there's a line. There's a line.
You still got 30 years to go then.
Yeah.
like maybe you'll be in Craig will want you.
Excuse me.
But anyway, I mean, I just think this guy, I think that's the reason why they didn't want to speculate too much. Because the prosecution does have a higher standard, and they can't just be like guessing and making shit up.
That's right.
And I think Jackson would have torn the prosecution. I could imagine the cross that would have occurred if they would have done that.
Like you said, you don't get to do that when you're going to put someone away for life or something like that. You have to I see what you're saying there.
And the defense tried to do it to disprove, but the problem is they did something that the prosecution wants to do, but no, they can't. But they did it for the prosecution, and that's a big mistake because you put into the minds of the jury that, like, oh shit, a taillight can shatter with an arm.
Right.
Yeah, right. Yeah. That was the first thing was how many times has anybody kept track? Okay, the very back at the very beginning, forget about Richard Green. He's done. He's toast. That guy's toast. That 227 search, okay, that's done.
Oh, they're not doing it.
But then they started off with he was in the basement because of the stairs. They think, oh, the help day, the stairs. Oh, basement.
Yeah, that's where
then they ran with that.
The altercation originally took place was the basement. Yeah.
Yeah. Then the phone data came out with a temperature thing. Oh, well, let's move him to the garage. And it's like, and then the whole thing about the scene itself. I mean, you don't hear the free Karen readers talk about the shoe. They will not talk about the shoe and the hat because they know there was no way it could have been planted. The shoe had been planted.
They talk about the shoe because you got the glare stating that there's a different shoe. The cops changed the shoe because the picture shows the bottom of the shoe darker than the one.
Well, that's ridiculous. That was the nighttime photo that we all know. That's those people that think that the moon landing was fake because you don't see stars and they don't understand. They don't understand apertures and f-stop aperture. Here, there's that word. But for camera settings, you set the aperture and the f-stop to try to. To capture things you want to capture. At nighttime, what happened was they had a light source from one angle. And we don't need to explain it. It's common sense stuff.
They didn't
it's common sense.
But the fact is that the
do you think they're going to get a shoe to try to plant a shoe and go, oh well, I couldn't find them. I
mean,
I gotta listen to this one.
I mean, what would you need to be? You go. I'm sorry, Kathy. I interrupted you.
Where did they have the time to do all this?
Yeah.
Amazon, baby.
Let's play a little Amazon.
They delivered to crime scenes.
Yeah, we figured it out. It was an Amazon truck, and they're covering it up. They're the ones that did it.
Can you see me a Nike shoe with a black sole on it? Sure, okay. I just need one.
Man, so it was Amazon. It makes sense. It was Bezos, that son of a bitch. Where was he at
least his size?
Yeah. So let's play a little.
Hey man, whatever happened to the I was so excited that they were going to put the ring guy on the witness list. But they never called him. Was that a diversion? What do you think that was about?
I think the prosecution was just readying for any variabilities that the defense might have.
Okay.
And I think that was the main reason. And I think what Hank noticed, because you have to realize we don't see the jury, and I think
He does though. He does, Petty, a bit. He does in a way. Yeah, it's wild. I have to agree with you.
He doesn't have we don't have the ability to see a jury, so he might be looking at the jury and see them. They're getting pissed.
It would only take 10 minutes, though. You know.
Well, I don't think
because they're not gonna maintain videos at Ring. They just don't do that. But they would maintain maybe login times and dates and things like that. Just say someone logged in at this time and on this date at this time. That's all we need. Did someone log in on a certain date and time after 12:32 on the 29th, 12:32 a.m. on the 29th? Anybody log in? Anybody log in? You know, and if so, you know, wouldn't mind having that IP address. But anyway, you know what I'm saying?
Nice troll account, by the way, tech support. But anyway,
you have got trolls here?
Yeah.
Oh yeah. You subbed up just to tell me that, because YouTube wouldn't come in my channel and spell
they would just
like that.
They would just ban you.
Yeah, they would just take my fucking live down.
Just take your down. They don't give notice. They're not like 4,000 subs.
Hey, but do me a favor, don't unsub. You know, just stay sub. That's okay. We won't block you yet.
Hit the like button though.
Hit that thumbs up. You know, share it out. Do all that YouTube stuff. Heck, I forgot to do a goal.
What the troll say? Is it repeatable?
No, they basically pretend to be YouTube saying we've been banned.
But I'm flagged.
And all that stuff.
Oh, I see it now. YouTube tech support. Oh my god!
And they didn't spell tech support correctly. They incorrectly spelled tech.
Petty, Craig's voice is a little deeper, but I get where you're coming from.
Tech.
But so I think you want to play more of it, Kathy?
Yeah.
Okay, look, I'm going to jump down. Thanks for having me up, guys. Yep.
Oh, well, thanks for coming up. I appreciate it.
I'm going to jump down and listen. Take care. Peace.
All right. Thank you.
Thank you for your opinions.
Thank you.
Okay, let's go.
And again, nothing on pedestrian accidents.
That's correct.
Expanded abstracts, you've written a few?
I have, yes, sir.
Suffice to say, dealing with wheelchairs?
And assistive technology, that's correct, yes, sir.
Any have to do with pedestrian collisions?
I don't believe so, no.
Wow.
Looking at your CV, you can note any area of specialty you'd like, correct?
You can put down whatever you like, I suppose, sure.
Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise I perform.
Now, Doctor, when you work with Dr. Wolf, did you have a chance to look at his report?
You just said that you didn't perform any pedestrian accident. So
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at the time, didn't you?
To some extent, yes.
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 G's.
And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
I talked to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration that the arm and hand experienced at a 29 mile per hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah. And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please? You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnosis, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you were critiquing Dr. Welch, correct?
Sustained.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to get the impression that you
I
read
worked my
them,
way
you were
with-
a doctor and you can interpret them?
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't get diagnoses, but if there's no fractures on an x-ray is diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report? Or were you doing a certain kind of, were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed or didn't show?
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what you read in a report?
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report?
Sustained enough.
But yeah, because then that wouldn't be his opinion. He's actually using someone else's opinion from the medical report. Correct?
Yeah, wouldn't that also be disregarding a diagnosis?
Mm-hmm.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an x-ray. Yes?
Sometimes x-rays are the best for looking at bony fractures. MRIs looking at soft tissue injuries.
Speaking of wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
You were talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence, and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit or struck by the vehicle?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle is going the same speed when it hits multiple different people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking in your experience.
No.
Can I stop? I gotta jump off soon, but I just wanted to state one thing. His statement about no bruising is quite interesting since I Googled it, and it says, yes, it's possible for a car collision to result in no visible bruising.
Right.
It can result in delay bruising, internal injuries. Basically, it could be a situation where what happens if, let's say, the blood was pooling in a certain location and didn't get a chance to pool in the bruise area. Like, these are things that could have easily happened. The Coulde could have mitigated the bruising. It's like there's a lot of variables that this doctor is not really paying attention. This biomechanical engineer is not really paying attention. There's a lot of situations.
Right. It very much could be. And that's all he has to say. He's really I don't know. He's hurting his testimony. Because if you just listen to the defense's testimony with him, you'd think he did good. But then when you hear the cross and you hear how yeah,
Oh, by the way, I gotta go. But thank you for having me up. I gotta.
Well, thank you.
Purple, by the way, that was a troll account. That YouTube tech support thing is a troll.
Yeah, that was not in purple. Thank you so much for coming up, and thank you for the super chat.
No problem. You have a good one. Bye.
You too.
I sure hope you have a good night.
Okay.
I'm going to allow that.
Have you ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different or in some cases no injuries? Is that going to happen from the outside?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people and different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries, and another case where you look at where there was a similar type collision with different injuries?
Exactly, Dorothy. He wasn't up.
So again, do you mean abrasion, cut, laceration, fracture? Do you mean same?
He was thrown. He wasn't up against a wall. Right, correct. He was thrown back. Yeah. Which, the way she hit him makes sense.
Cars, it's not something that you look for and compare between cases. You'd have to go back and actually study the cases and look at the details.
Having experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow that. Can you?
Do you mean hit the same way with the same type of car at the same speed with the same force?
I'm going to allow it. Can you answer?
I don't believe I've ever seen a case where two people were hit with the same car at the same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations.
That it could, it does.
Mm-hmm.
Doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're
Israel, the CBS reports that Israel has informed U.S. officials it is fully ready to launch an operation against Iran. Oh my. It never stops. It just never stops. Yes, pray for peace. So many innocent people are just killed every day over that. It's just crazy.
It's getting out of control more and more.
I swear the killing never stops. It just never stops. Here, Dookie.
Well, you know what, Kathy? I just was looking for all the riots. Now they have a little one going on in my in Detroit.
Mm-hmm.
So now it is all over the country.
Yeah, it's been New York, Atlanta, here, LA. It's been Ohio, everywhere. Yeah.
I thought we
I
were
did
going
a
to be
little
the
bit of
good
it
state.
yesterday.
I thought we were going to be the good state, damn it.
Right.
claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Well, sure. I mean, the testing we've done here, the taillights covers fracture differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll get to the contact. When you look at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that. And I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
It's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Bennett. No more comments.
Oh, he's
When you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not matter if there's a need, did you?
I did not, no, sir.
You had talked.
There's a map showing where all protesters will be on Saturday.
Quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I don't allow it.
Well, that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, I'm going to see counsel at sidebar.
Uh-oh.
So it will be the luncheon recess and we'll take an hour.
Sidebar.
Dr. Rentschler, you wrote a report back in February 2024?
Yeah, that's correct, yes, sir.
And in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm?
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury?
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at it, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
In the x-rays that we looked at, or that we saw and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
A crash test dummy is different than a person, isn't it?
Certainly it is, yes.
No
sir.
muscle?
That's correct.
No ligaments?
That's correct.
The crash test dummy does not react or respond like a human being?
Well, it does to a certain extent, yes.
There are differences?
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside?
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside?
No, of course, they're not the same, no, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the paint test, correct?
Well, I was referring to there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those
references?
references?
You didn't read any?
We don't allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were... 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this.
The reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 cites, didn't you?
In soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of cites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy, in the material of a crash test dummy, to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite, supporting the claim that you made.
He's doing a really good job of wrecking this dude's testimony.
Mm-hmm.
He's doing a really good job of it.
This guy is so discreditable. I don't even know why he's still up here.
Do you guys want to take a break from this and do a peek in on the TurtleBoy stuff?
Oh, sure. I've been watching some of him. He's a nut.
Oh, thank you for the PayPal. I don't know your YouTube name, so I don't want to say your name out loud. But thank you very much. I really appreciate that. That is so sweet of you. Very kind. I appreciate that. I hope you're still in here. You guys want to keep going, or you want to take a break from this and come back, or what?
Whatever.
Yeah, he is. He's just with every question, just chipping away at this dude's testimony, in my opinion. I mean, every question is a hit.
Yeah, and his attitude. This guy's kind of like a little agitated with this lawyer. He should calm down.
He gets even more agitated. We can stay with it if you want to. We'll just stay with it for a little bit. Maybe I'll fast forward a little bit.
Hey, I'm very
There's nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cuttability and its Relation to Lacerations Severity Indices. You know that. You cited that.
That's correct. And it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites.
His lawyer brought up her as being a bad babysitter.
Camille's leather and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cuttability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it's different, sure. Yeah. And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not.
Then why did you use them?
You cited number 20.
Why did? Wait a minute.
25. You cited
That's what you cited, but you didn't even use them. You didn't. I don't know, dude. He is sitting here, just one by one. Every time he asks you something, just chipping away.
Mm-hmm. I don't even understand why this guy was even a part of anything, but other than being a paid idiot.
I do the same thing, Purple Dragon. I procrastinate about it.
Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that
Thank
crash
you,
test dummies are
Summer Girl, for
appropriate
coming in.
to use when making this type of
Appreciate
analysis,
you.
does it?
Correct, and that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure, I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the Hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Yes.
Have you ever heard of the
details matter? Yes, he did. And that's why he keeps bringing it up. And now he's ignoring pieces of evidence. He's ignoring a lot of details, but details matter.
Yeah.
Like I said, he's chipping away at this dude's testimony and he's hitting home.
And I would say he's not doing that at a slow pace either. He's really digging at this guy.
But it's questions he should be able to straightforward answer.
Yeah.
And not talk in circles and try to avoid answering the question or not giving a straight answer that he could give.
Person by the name of Stanley Bakatis.
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field of crash test dummies?
He is, yes.
Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation position of the lacerations are consistent with the orientation position of the tail light cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence.
Yeah, but there's actual video showing that a piece of the tail light matches up exactly to an area on the arm where all the cuts are. So, I mean, dude.
Is it that real long, deep one?
I have to go over to Twisted Tragedies and look. If you guys want to watch the coverage, she's been streaming it since it started with the first trial. She doesn't miss. And I used to go, when I had the time, that's where I go. I like Elise.
That he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the tail light cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
And neither do you.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that?
Inferred that that's how he believes that the arm was positioned.
I think we understand your perspective is that's the only test he performed. But what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle.
I like Elise. And that's where I would go to for my Karen Reed info. And when I could, I'd go up on panel with her. I'm going to have to make some more time and go over there. She has been through it with the Karen Reed supporters and the TurtleBoy cult.
That occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
I may take you up on that because I do miss a lot. Unfortunately, I do.
That's very nice of you, Purple Dragon.
I appreciate that. Thank you.
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished or represented.
You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the tail light cover. If it doesn't represent that, you're right, I changed my opinion that there's no evidence.
If you have an email, my email's on my channel in my about section. Email me so I have your email so we can. That could be very helpful. Thank you.
Analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
Yes. I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
You know whether Dr. Welcher has been clear that he does not know? Let me say this differently. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in collision.
He does not state what he thinks the speed is, that's correct.
He never states how far, if at all, Mr. Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of your body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that actually occurred. That's the basis. Yeah.
So,
if you don't have the information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
So you would.
And if you ignore it, same thing.
Sat here and broke my dang lighter. I got tired of buying the Bics and wasting them. Because, they're like $3 here almost.
Oh, yeah.
It's a fast store. So, the quick stop gas station stores. So I decided, okay, well, since I'm not doing nothing but burning them away, clicking them, I bought cheapies. Well, guess what? Don't do that. Yeah, well, this cheapie's still full, but it won't light because the flint breaks. The thing breaks in them when you flick them, and I flick it a lot. So
I like it when you your back. It just means you're staying calm.
Yeah. Well, no, I do that so I don't. It keeps me. It's weird, but it does. It keeps me from not smoking.
Hey, I don't mind it. Go for it.
Okay.
What to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision. That wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the road distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
But see, you don't know because you didn't have the accurate information. You only had what the defense wanted you to have.
Yep.
So you couldn't have.
There's no way.
Yeah, he just chipped all away at your testimony, dude.
There's no way he could know anything when, first off, you're given such a limited to do anything. I mean, how's he gonna do his total? What's that word? Hypothesis or whatever that is.
Mm-hmm.
If you don't have everything there.
Yeah.
You can't. You're
My
just
local gas station gives you a cheap lighter whenever you buy a carton. Oh, how generous of them after you spend $70, $80 for a freaking carton. How generous.
Oh, loot I can send Kathy.
My thumb actually got sore from that cheap ass lighter. Anyway, that was my stupid fault. Anyway.
Go back to the Bics, honey.
So, if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you? In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of the collision?
He did not state that. That's correct.
So when you've made your criticisms that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement on it that he was trying to reenact the actual collision?
When I did that, there was one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again.
Exactly, Darby.
There is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision.
Okay.
It's not anywhere in there when he stated that.
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test.
The look on her face of worry tells me she knows that their big closing witness just got chipped away.
Yeah, she don't look happy, does she? She's not smiling.
You could tell just by how they were reacting.
Mm-hmm.
I'm curious to see what the actual intent was.
Is the answer no? It's not in there.
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again. Is the answer no?
And since there's no rebuttal, just closings on Friday. Tomorrow is motions day. They're hearing charges, stuff like that. There's things they have to settle, but Friday it should be going. The jury should get. They should have closings on Friday. Maybe I'll stream that. I'll see if I'm. Oh, I can't. I might. I'll try to stream some of it. I forgot to go to Jeff's. Anyway.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some, or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, Doctor?
I don't know, is it?
What? I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to...
What Hank is getting at is ARCA didn't disprove the collision. They disproved Dr. Welcher, who never said he was proving a collision. Their entire foundation was skewed. They disproved nothing. Yeah. They honestly, they didn't. And he's sitting here, and the things that he's saying and the way he's being combative, not wanting to answer because the answers don't fit what they've already put out here.
Mm-hmm.
It just, I think it hurt his testimony. What isn't the wham bam closing, they wanted it to be.
No, this lawyer ate
or
him
they
up.
think it was.
I gotta say, the second they showed the lawyer, I was a little embarrassed for the guy on the stand because the lawyer does look like he knows more.
Mm-hmm.
I mean, just in general.
Sheila, I got to plan a party for her. She's going to be 3 years old on Monday.
Aww.
So I got to plan her a party for
That's
a
a
3-year-old.
beautiful age. They just love parties.
Yeah, well.
You go for it, Gabby.
Yeah. I think she would look cute, do a luau party, but I can't. But I would love to, have her. She would look adorable with a little grass skirt on, She would look cute.
That is so cute.
But she likes Minnie Mouse and Hello Kitty. But she
right.
loves Minnie Mouse.
I love Hello Kitty since I was a girl.
Mm-hmm. Yeah, in fact, my daughter just gave her, she had a Minnie Mouse that plush that she never, just sat with all her stuffed animals up in her net. So she got down and gave it to her. She was just so thrilled. And she carries that damn Minnie everywhere.
Aww.
She's a doll.
I wanted to tell you something, Kathy. This guy said he never saw two people get hit by the same car at the same speed. Well, I want to tell him that I did. I was with another gentleman, and the same car hit both of us. Both his knees were broken. I broke my bad leg.
Well, impact, Frank.
And
people are getting hit by this. Go ahead. I'm going to ask my husband something. Go ahead.
Okay.
Go ahead and talk. Or I'm sorry. Go ahead and talk, Freddie.
Oh, okay. I'm sorry. I was just waiting. But what I was saying is it broke both of our legs. It broke his knees, and it took my neck out all the way down. Got a severe head injury. So if he hasn't seen anything like that, I mean, then maybe he's not really a good guy. I don't know. Just kind of shocks me that he would say no. Please hit the like button, and thank you for being here.
That's what I just said. Yeah, I don't think that. Yeah, he doesn't. He doesn't agree, or he's like, nah,
and this is how it occurred. You have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing
But you didn't, so then you can't prove anything actually happened, which you didn't. I mean, ooh.
Task to prove something, you have to look at how those variables may affect it.
I think I'm beginning to agree. I wasn't too sure how I felt about the no rebuttals, but in the defense's situation, I think that was a good move for them. A really good. He can't backtrack this one. He's trying.
Well, it's going to be fun, huh?
There's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself
Absolutely,
where there were
yes.
variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
But you don't.
How many cases have you done on pedestrian accidents?
I've done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not know.
Were you even there when they happened?
I was not, no, sir.
So you're relying, in part, on Dr. Wolf's work?
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift, if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually, it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
You've seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move. Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash tests with crash test dummy where there was a light? I'm sorry.
Wow.
Have you seen crash tests with crash test dummies where there was a light string and somebody cuts the string moments before the impact or a second before the impact?
Yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower.
I think he's doing it to try to control himself because he's working really hard to control himself.
Yeah, he's very agitated.
Yeah.
If you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion. And you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault.
They sound like you're
Fender vault is a different type of collision than a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios of the crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Renschel's PowerPoint, please? In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes.
And you put snippets up on the board?
Yes.
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Okay. Is there a reason why you took out a piece of that article that falls between
they're trying to take my ass
No, I don't think so,
out?
no. Those are the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle, where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet. And these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions, because that is the majority of pedestrian collisions, the front end, isn't it?
The majority, it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct, and that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was E, the
24 miles per hour.
No, it didn't hit the center of mass of the gun. It just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle?
So ask the question again.
You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
We have no information that he was even hit by the Lexus, so there wouldn't be any information on the angle if his body wasn't hit.
When you talk,
you were given inaccurate, incomplete information to do your testing in your report.
With limited resources.
Mm-hmm. Yeah, within the budget.
Mm-hmm.
About force
And he
equations with this
admits
jury.
lying.
You cited a number of pieces of literature, didn't you?
I did, yes.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand.
Yes.
Could we see slide 8, please? You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
Well, that was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
But we're assuming the center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with a hand. But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
There's a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contact. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So, for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they used the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data?
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow it.
I'll strike it. Did you consider Apple healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Were those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know where the debris field is?
Yes, sir.
And you've seen in your videos, E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from? Is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's...
So then you can't... Dude. He's already admitted that his I'm sorry, but his whole testimony is shot down back. I mean, he's admitted he wasn't even given the correct information to begin with.
Yeah. And he admitted to lying, and he admitted to not having the proper resources, and the guy's just done.
And he don't ignore no evidence. And then he's listed things that didn't have anything to do. I don't know. I think the state has done a good job on this witness, on their cross. I think it, yeah.
You know,
I can't wait for the closing arguments.
When they mentioned the high heel, I just went, whoa, that might be a high heel she hit him with. You know, looks dangerous.
They can be. I had a call once where one was stuck in the dude's face. And his old lady just whacked him with it. His biggest failing is it is scientifically impossible to prove a negative. And he's claiming they did. He keeps banging on about science, but science itself says he can't do what he claims they did. Yeah, and that's where Hank is. Hank is he's on this. He knows. Like I said, he's chipping away at him. He knows. I feel like this guy should be made to go take a rug test. Him weaving and wobbling is sus to me for real. I thought he was doing it because of nerves and because he's. It's like you can see his eyes get real fired up, and I think he's trying to control it all in because he is not. He knows that this cross is just eating up his testimony.
Oh, I've seen him rolling his eyes.
Yeah, he knows that they've got him cornered, and it's his own words that have done it. It's a self-soothing thing, anger management. Yeah.
In a collision, have you seen the debris fields?
I have, yes.
Have you seen the debris fields where a taillight was shattered?
I have, yes.
In fact, in your video, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you are looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. It has nothing to do with the injuries or the position or the movement of the
Exhibit
individual.
73, please. Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Is that an alleged part of the taillight cover, or do you think that's part of the taillight cover, sir?
I don't know specifically. It might be part of the actual taillight
Well,
cover.
when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
yes.
What I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of it?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all that would be from something else. So unless you prove the core issue of this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have exhibit 76A, please?
What? We didn't evaluate.
Did you see this photograph, sir?
Wow.
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies that this taillight shard was found in front of 34 Fairview Road?
Well, sir, can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none, so no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 990. Do you know what that is, sir?
That's evidence that he's ignoring, isn't it?
Yes. Evidence to the accident and evidence to the trial.
It looks like part of the other.
And it may not be relevant to what he was doing, but it's nonetheless evidence.
I think it would be relevant to what he was supposed to be doing.
The light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look
his
at the
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those?
It says I reviewed medical records and reports. And that's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please.
All right, Purple Dragon. Yeah, I can only record on a certain thing too. I hear you. All right.
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
So his specific job was only to say or to, in their minds, do a reenactment to prove that he wasn't hit by the car, but none of the other stuff mattered. He didn't do anything with it. He didn't consider any of the evidence.
Right. So incompetent, maybe?
I don't know.
Or
Hey, Blake Screen.
paid to be incompetent.
Yeah, that troll's been coming in all night telling me. Yeah. Thank you, Blank Screen.
Don't know that I have.
Have you ever seen any container that had taillight shards that matched the defendant's Lexus that were removed from his sweatshirt and shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please?
Dude, but if the car never hit him, how did he have the taillight pieces on him in his clothing? How? If the car never hit him. You don't think that, I don't know. I don't know how that's not relative. Uh-oh, the little one's crying.
Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight?
Yes.
That were recovered from Mr. O'Keefe's sweater or shirt?
Objection. I'm going to allow that. Did you consider that?
I'll try. I'd rather try to reformat than come sidebar. Did you know that taillight shards were collected after Mr. O'Keefe's sweatshirt and t-shirt was scraped?
Objection. I'm going to allow that. I need to see this. Jurors, this will be brief.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his t-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis, to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
I'll try again.
Okay.
When you look at these taillight shards that were... Objection.
Go ahead, Mr. Brady.
When you look at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes?
Objection. Same objection. I understand the objection. Word it differently. Start with the different one.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keefe's clothes?
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Reed's Lexus?
I do, yes.
In your studies in the enactments, did you make any determinations how these pieces of broken plastic got into Mr. O'Keefe's clothes?
No, when you look at those studies, first you have...
Are you muted, Kathy?
Here's another problem. Wolf said he would expect debris to be embedded in the shirt, and it was. They ignored it. Yeah, he's ignored a lot of things. And that's why I asked, well, if he wasn't hit by the car, how did the taillight pieces get embedded in his clothing, his shirt?
Have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened.
You've already said that your testimony is he didn't get hit by that car. But you considered, I don't, okay.
When you ignore all the evidence, I mean, I guess you're not going to come up with the right answer, sir.
You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess, apparently, to actually cause this incident to occur. And without that evidence of any of that...
bumper and undercarriage of the car. I do.
Mm-hmm.
That's just my opinion.
Happening, knowing how the body moved, knowing how it was hit, knowing where it ended up. Any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
But...
Could I have exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? You understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you. Do you understand?
So
that?
that's what you're telling me then.
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers in the other plastic, is that something you would want to consider in your analysis, forming your opinion whether or not it was a collision between Ms. Reed's car and Ms. Gilkey?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and action reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and the dynamics before.
Dude, the tail light pieces embedded into his clothing, he was hit. I mean, come on.
This could certainly support that finding.
His hair in the bumper. I mean,
those conclusions. But by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
If you disagree, do you think they're not sharp?
I don't have an opinion as to that, sir.
Take a look. Objection. Sustained. If you look at that from behind it, can you tell me whether you think those pieces of broken plastic are sharp? Objection. I'm going to allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
let's go back
looking
to
at them online.
Perhaps that can help. Not under a microscope. If you've paid...
Yeah, the tail light, the DNA. This man is claiming DNA on the tail lamp is irrelevant to contact between a human and a car. All he's done is convince me to never engage ARCA for anything ever. I could use them if I wanted. Yeah, he says you don't ignore any evidence. He's ignored a ton. And how can he come to his conclusion without, I mean, there's DNA, he's got the chips from the pieces of the tail light embedded in his clothing. Yeah, I think the state did a good job with this. I really do.
It's really not too confusing, is it, Kathy? Like he's trying to make it.
Yeah, he's very combative too. He's very well, maybe combative isn't the word.
I would say nervous and agitated, maybe.
Yeah, he wasn't being he was being defiant, and and you could tell that he was getting himself in check many times. But we're going to change it up here. I want to look a little bit at what went on.
TurtleBoy, we're coming
with
for
TurtleBoy in court.
I gotta say, you got a good chat tonight. Very informational. Thank you, people. Thank you.
Yeah, I knew it'd be small because it's Karen Reed. But,
it don't matter. I'm here anyway. I'd be the only one in your chat.
I appreciate that. Okay, where's it at? I have it. This is Grant. Posted this today. He posts everything going on with these trials.
When I first looked at TurtleBoy, I gotta say, I don't like or dislike Musk, but he sure has that creepy look like Elon Musk.
Yeah, all right, come on. He posts a lot, so here it is. Okay. Let me show more. Let me share screen. This is what is going on. This is TurtleBoy's been in court 2 days. And there's a chance that, I mean, so this is what Grant had to say. I don't want to say Lindsay's last name. And Aiden Kearney, aka TurtleBoy. Lindsay took the stand and humiliated Aiden TurtleBoy Kearney's lawyer on cross. Apparently, there's no video. I wish there was. If there is, I'll find it. You know what? I didn't even Mass Troll or Yellow Cottage might have it. I didn't even think about that. I don't think there was, because if there was, Grant would be showing clips of it. No. Okay. So we'll just read it. Hank Brennan shined on cross of the final Reed defense witness from Arca. Yes, he certainly did. And both Kearney and Karen could be headed for convictions within days. Lindsay did so well on cross by Timmy Bradle. In fact, that Bradle became combative, which is TurtleBoy's attorney.
Mm-hmm.
He's a real jerk, too.
Mm-hmm.
He became combative and was shut down during multiple lines of questioning from the judge. Also on cross, Lindsay confirmed that it was Kate, Mafia Masshole, who told Lindsay that the O'Keefe family wanted Lindsay to go to court on 2/26/24 to show support for Lindsay. But why would they tell Lynn that the O'Keefe family wanted to go to show support for Lindsay? Kate told the O'Keefes Lindsay wanted to support them that day. The biggest moment of the day in the TurtleBoy case, however, was when Aiden TurtleBoy Kearney's defense lost their motion to play a video in open court of Lindsay's former partner approaching Lindsay in a parking lot and causing her to be in fear and break down. Because that has no bearing on anything with TurtleBoy. Kearney's lawyer tried to say Lindsay found the man that day, but Lindsay pointed out she was in the parking lot first, and the quiet, horrifying man in question found her and caused her to be in fear, thus entirely undermining Bradle's cross and leaving Lindsay standing tall. Voice firm as Bradle whimpered an end to his questioning without so much as a decent final question. Kearney's trial will continue at 11 a.m. on Thursday in Dedham District Court as the final state witnesses take the stand. Then Kearney will put on a defense and closing statements will be provided. Then the judge in the case will render a verdict. Yeah, he didn't do a jury trial. He did a bench trial. Yeah, I don't know if I'd have did that. It says, after a strong case from the prosecutor and former judge Robert Cosgrove that included 2 court officers, 2 police officers, and a digital expert, the crescendo was truly Lindsay taking the stand.
She's got to take the stand.
No, she did. Lindsay did. And she fucking destroyed TurtleBoy's attorney. That's what I just read.
Good, good.
Yeah, I wish there was video.
He's been stalking her, right?
Yeah.
Yeah. Why?
Oh, the order's against him. He's not supposed to.
Right. Yeah.
Okay.
That's what I thought.
And here's some more about it. Earlier on Wednesday, Lindsay has formally became the second named survivor to take the stand in a criminal trial against Aiden TurtleBoy Kearney, following Ashley's St. Angelo, who also held Kearney accountable via the criminal and civil court process. Lindsay took the stand under direct from Cosgrove and told the judge and Kearney's ongoing trial that Lindsay did not know Kearney was at court on 2/26/24, and that Kearney stood in the bushes and yelled "liar" at Lindsay after Kearney was told to leave the area because of Lindsay's then active RO against Kearney. Then, in moments that defied belief, Lindsay recalled from memory what she was wearing on the day in question and told the judge that she discovered her car damaged after walking past Kearney, who was hiding in the bushes. Then Lindsay told the judge that she called the police to report her damaged car, mentioned the RO she held against Kearney and his presence, but had to run home because the babysitter for her children had to leave soon. Later that day, and I don't blame her, but, your kid's got to come up. And, it could take a long time for an officer to even get there. That's not going to be a priority.
Right.
Later that day, Lindsay told the judge, Lindsay called the Dedham police, went down to the station at their request, and formally reported Kearney for the RO violation. Also, on direct, Prosecutor Cosgrove had Lindsay read into the record TurtleBoy's own blog articles about Lindsay as part of the state's case in chief. Then Cosgrove had Lindsay describe pictures from Aiden TurtleBoy Kearney's own blogs to prove Kearney took pictures of Lindsay outside Norfolk Superior Court after a John O'Keefe and Karen Reed retrial on 2/26/24. This is what I mean. He is so blatantly ignorant and thinks that he's above everybody else.
Mm-hmm. He don't have to follow any rules. He's above the law as well.
What's that link for, beautiful? I appreciate it. And he's not stopped the harassment of the witnesses. He's not stopped the harassment of this woman. I'm not sure about Ashley. It doesn't end with him. He just, no matter what.
Oh, she found a link for the case.
I got from Google that is supposed to be TurtleBoy Court. I don't know if the creator at all. Just trying to find the video. Oh, so it might work. Shoot. I wish you could put it in back chat. Can you put it in back chat so I could click on it and see? It could be, what I've been looking for. Thank you. I appreciate that. Hey, Bree. Thank you. I really appreciate that. Because, maybe I can click it on here. Let me click it on here. I don't know if it'll let me. Yes. I was able to click it on my tablet. Oh, it is. I didn't know that. How long is it? It's only an hour. My husband's probably going to get mad at me. But wouldn't you rather hear it than me reading it?
Yeah. Well, no offense, but yeah.
Thank you very much, beautiful disaster.
Absolutely. Thank you.
No, if it'll just save for me.
You're a beautiful, organized disaster.
Why won't it save? I'll just look for the young jerks. Yeah, because that saves me from reading it. Now I know where to go for. Thank you. I really appreciate that.
Yeah. You were doing a fine job reading it, though. I just want you to know.
And look, they came right up. That's unusual forever for me. And I'll make sure I drop their link in chat. And I will be fair using this. This is covered under your fair use, but I will make sure. In fact, I'm going to do that right now. Copy the link. And I also will put it in the description.
He's a bad turtle. He moves too fast and dysfunction, eh?
Bad turtle. I got it. Beautiful disaster. I can't thank you enough. Thank you. That was awesome of you to find that for me. Thank you very much. Okay, here we go.
And you wanted to talk about what you said to Kozak, right? Kozak, right?
I explained her that she know they had already spoken to an officer.
Let me turn that down a little bit.
Order against the blogger that was covering the case, but he was in the courtroom. They made him leave the courtroom when I got in there, but then after I guess he was waiting outside on the steps for me afterwards. I had my restraining order says he's not allowed to be within 100 yards, and he was outside yelling stuff about me within the 100 yards as I came out from the courthouse. So I'm just trying to see how to report this violation. What I'm supposed to do. I have to.
So you're trying to see how you report this violation. That's different than as if you reported it and you're following up, isn't it?
Objection sustained. Counsel can argue whichever way you want to characterize it.
So that's not following up, is it?
Objection sustained.
You're trying to ask how to report it, right?
I wasn't sure what Officer Kozak was going to do, pertaining to the follow-up in regards to the family and the answer about what was going to happen reporting the violation. So
You claim that you had just walked by Mr. Carney violating your restraining order.
Hey, it's me. I'm trying to figure out how to get this link to drop for you.
Kathy, are you muted?
Not muted.
Oh, okay.
Oh, she just wanted to come up for that link. Okay. Thank you again. I appreciate that. Let me take my thing down. Okay.
5 minutes prior, right? And yet it's your testimony that you're more worried about a scratch to your car than using the ammo you just developed that you could get locked up.
was I more worried about a scratch in the car? No, it wasn't just a scratch. It was almost $1,000 in damage. I just paid $2,000 to fix my car. I just got it back a week or two prior before that. So I was very upset to come out and see my car and get it back.
So you know how to get someone in trouble when they violate a restraining order, don't you?
Objection. Overruled.
You know what to do.
How to get somebody in trouble?
Yeah.
I know how to report to call the police. I know how to call the police.
And you
I'll
know
try
that
slowing
if you
it down
insist
some
that someone's
more.
violating the order, they are obligated.
Yeah, she sounds a little fast.
Yeah, I slowed it down even some more.
Uh-huh.
But you can come back if you'd like to, beautiful disaster. I really appreciate you doing that. Thank you.
Oh, please come give you
she sounded she's hard to understand. So I slowed it down a little bit more.
like she talks fast already.
Yeah, or they're muffling it. I don't know. It's weird.
Mm-hmm.
He sounds
Objection
clear.
overruled. If the witness knows.
I don't have the obligation to report.
You don't know that if you're in the presence of someone, you have a restraining order, and you tell a policeman on the scene, I have a restraining order, he's violating it, that they don't have to arrest him? So you knew that you could have caused him to be arrested on that very occasion. Isn't that right?
No, somebody. You can be arrested.
And you claim that you saw Mr. Carney breaking the law, right? And this isn't the first time that you've gone to someone and then tried to get them arrested for violating an order that you triggered the violation of, is it?
Objection. Objection sustained. Violation hasn't been found.
Sure. Who's Frank Egan?
Father of my 3 youngest children.
On the restraining order, do 4 of your kids have his last name?
Objection sustained.
So he's the father of 3 of your children?
What does that matter?
And you had a restraining order on him, didn't you? And when was that time period? How about what year?
I don't remember when I first saw it.
You can't even say what year it was?
Yeah.
It was before you got involved with Mr. Carney, right? So was it before 2023?
I don't know.
How about on July 27th, 2023? Was it in place then?
That may have been then audit. I believe. I'm not sure.
And sometime after that, you located him in a store parking lot. You went into his car, you sat down, and you called the police on him, didn't you?
No.
Judge, I'd like to play the tape recording.
I object.
Okay, well, I hope it's coming up soon. Because she sounded like, I don't know, like she's intimidated by this guy, but they say that she comes back and shuts him down. So he's a mouthpiece, that's for sure.
Yeah, she sounds a little intimidated.
Mm-hmm. You can't even hear them. Oh, they're at sidebar. Well, we should be here at anything anyway. Alright, let's fast forward.
Chances of that video. You've seen that video, right?
Was it all?
So that's a yes? Okay. Mr. Keegan was trying to get his oil changed, and he was driving down Main Street in Walpole, and he pulls into the CVS parking lot in Walpole, and then you pulled up next to his car, and you got in his vehicle, right? Well, can we agree that you got in his vehicle?
Yeah.
And can we agree that you called the police? Okay. Someone else called the police.
I didn't call the police.
Okay. And just sort of alluding to prior questions that I asked you, you had a restraining order on him, right? And that means that you went to a court and said, I'm afraid of this guy, keep him away from me.
Objection.
Oh.
Objection sustained.
You represented to a court that you were in fear of imminent bodily harm, correct?
Were they in a nasty custody battle? In divorce?
Okay. And you asked specifically to keep him away from you.
Okay, but they could have been in a nasty custody battle or a nasty divorce.
Nasty breakup.
Yeah, what Aiden did was gross and continued to do to this woman, no matter how you spin it. You know, dude, no matter how you spin it. And she's not the only one. The things he did to the witnesses, heck, he was even calling the state attorney's house. Come on.
Wow.
The police chief, he was calling them all. Going to people's homes, businesses, school events.
School events?
Yeah, there was the teenager that TurtleBoy turned everybody on and said that he's the one that did that. Murmur John. He was in his last years of high school. In fact, he had a scholarship, and they destroyed this kid. They went after his friends on social media. Oh my God, they stalked his parents, his home. They went, if he had a game, TurtleBoy was there harassing them. Yeah.
Wow.
Recorded it all and put it on his channel. I played it.
He needs to be locked up.
Well, he's facing, I think, 17, 18 felony charges.
Well, I hope
and she had a restraining order against him that he violated. And that's what this is about. I'm just waiting for her to. They say she hands him. You know what I read in Grant's rundown of the trial. He said that she owned this lawyer. Well, I'm waiting to see it because so far I haven't. But she's like really hard to hear.
She seems like she's keeping up with him, though. I don't know if she's like giving the right answers because she is hard to hear, but she seems to be keeping up with him, even though intimidated.
Right?
Objection overruled.
Yeah.
and you got an order that said, probably similar to this one, that he needed to stay probably 100 yards from you, right? And yet, when you saw him, you went to him and you got in his car a couple of feet away from him, right?
That person. He followed me there.
So your children again, you're taking care of your children again, right? And it's just a chance encounter.
He's been calling me all day. Found out there was cousins in my lunch and pulled into the parking lot next to me while I was in the drive-thru line for the pharmacy. My window was down, passenger window, yelling at me to pull over. Come over the car next to him. He wanted to talk to me. Trying to pull over next to him. I didn't get out of my car at that point. I stayed in the driver's seat. My window was down. He came over, asked me over and over for me to get out of my car to talk to him.
Isn't it true that he asked you over and over to get out of his car so that he could go get his oil changed?
Started screaming, threatening me, tried to drive away with my leg up the door. Yeah.
Yeah.
I started recording after all of that.
So he tried to
Slowing it
drive
down's
away
not making a
with your leg
difference.
out the door.
No, I'm understanding her better.
Pretending, practicing it.
Isn't it true that the video shows him not even in the car?
Mr. Brito, the video speaks for itself.
Thank you.
Do you have anything further on this, or are you going to move on?
No, Judge, I'll move on. Thank you.
The judge had enough of you badgering the witness.
So back to the Registry of Deeds parking lot. Who did you talk to arrange for you to meet that group in the parking lot?
And I talked to the arranged meet the group.
You don't need to repeat my words. If you want to just take a minute, think about them, and then answer, that'd be fine.
It was Peter who told me that I was invited, but to arrange to meet the group, I don't recall.
Did you speak with Jennifer McCabe about going to that spot?
I said earlier, I called her to invest the parking lot, but I don't remember if I spoke to her prior to that. I just don't remember.
Kate Peter told you that Paul O'Keefe wanted you to be there, right? And then you responded to her words to the effect through a text, Paul O'Keefe wants to talk to me, right?
We're completing two completely different conversations. Completely different things.
Sure. So Paul O'Keefe
It stopped. Wait. Okay. They must be on a break.
Number 35.
There's a
the next picture, kind of a wider angle shot of the courtroom that day.
Yeah.
And you're in the second row on the left side, correct? Paul O'Keefe is the gentleman in the row ahead of you on the end, right? He's got a red colored sweater on.
Yes.
And this is a fair and accurate picture of where everybody was at that moment in time. All right, and further with respect to this picture, it shows Mr. Carney and Ms. O'Neill walking out, right?
Yeah.
They're offered to start as
Number 36.
And you said that it was a couple of minutes between when you walked in the courtroom and when Miss O'Neill and Mr. Carney left, right? Does 19 seconds sound about a little more accurate? And isn't it true that no one had to tell Mr. Carney to leave the courtroom, right?
I thought what also.
And your testimony is that he looked back at you coming into the room and mouthed the F word when he saw you. Is that right? Judge, I'd like to play a video at this particular moment.
Yes.
Thank you. Okay. And if we could just go up to 445, please. We have a little warm up.
Yeah, you know what? I'll turn it on. Yeah, she's hard to understand.
We are on the record on Commonwealth of Karen Reed on docket 22-117. Beginning with the prosecution, please apply to introduce himself.
Good afternoon, Your Honor.
Good afternoon, Mr. Blackburn. Good afternoon, Your Honor. Alan Jackson on behalf of Ms.
Good afternoon, Mr. Jackson. Good afternoon, Your Honor. Elizabeth Little.
Good afternoon.
Did you see Mr. Carney stand up there?
Yes.
Mr. Carney stood up, looked towards the window, and then turned around and went to leave, right?
I don't get to right now, so I was going right after this shot.
How would she know?
On behalf of Ms. Reed.
Good afternoon, Ms. Little. Good afternoon, Your Honor. Good afternoon, Ms. Giannetti. Good afternoon, Ms. Reed. Oh, all right. So here comes Mr. Rowley. Are you expecting him, Ms. McLaughlin? All right. I'm sorry. I would not have started.
Thank you. And then by then you had already entered and sat where the picture's shown.
Doesn't matter.
right?
He shouldn't have been there.
Yeah.
Yeah. He shouldn't have been there.
So Mr. Carney left with Ms. O'Neill, and you stayed in there to watch the hearing, right?
Right.
And what was your purpose in going there that day? And who's the family? Who invited you, and how did that transpire?
Just
All of you wanting me to attend the hearing because they wanted to show their support and solidarity.
And it had nothing to do with the fact that you had a restraining order and you could cause the eviction of Mr. Carney.
Okay.
And are they still supporting you now that you don't have a restraining order, or is that still in place? Well, you haven't been to any hearings, have you?
I went to the protest this time.
You haven't been to any court hearings, have you?
Not invited because they were not public in.
So that was just the one hearing that you wanted to attend, and you had, Mr. Carney had just gotten out of jail, and you had a restraining order at the time, right?
But then once the trial started, they didn't allow the public to go in because of the small footprint.
And did you bring your restraining order with you on March 20th?
Bring it everywhere.
So getting back to 226, you had your restraining order in your hand with you when you walked into the building, right? And it's your testimony that you didn't have it in your hand when you walked into the courtroom?
Courtroom? Yeah.
How about, so let's start, sorry, I was confused. So when you walked into the courthouse, you had it and you showed it to a court officer, didn't you?
I went to security. I was asked to take it out to show the campus.
So who asked you to do that?
One of the court officers.
Can you describe them?
I don't remember.
When did you first learn
This is
that
wild.
Mr. Carney was in the court?
Sometimes her comments show up, or her testimony shows up, and sometimes it doesn't. It's wild.
I was noticing that.
Yeah.
I don't know. I think when we were in the hallway after we were brought in to go enter the courtroom, and we were standing near the glass panes or glass panel, and they actually saw him going there.
And you were there for the sole purpose of evicting Mr. Carney at the behest of the O'Keefes and the Alberts and the McCabe's, weren't you?
So it's not.
It was just a coincidence that Mr. Carney had just gotten out of jail. This was the first hearing he was going to attend as a journalist. And that's when you get invited by the family, right?
I had only just begun talking to the witnesses because he went to jail and was getting harassed like they were. That's how we started talking.
It was just a coincidence.
No, I don't believe that because at all. That's how we met. That's how we became close and became friends.
You let them use you to evict Mr. Carney from the courtroom, and you were all too happy to do it, weren't you?
Bull.
So, Mr. Carney leaves with Ms. O'Neill, and the hearing's over in like 10 minutes, right? It was a lot quicker and a lot shorter than you anticipated, wasn't it?
I don't know how long it would be, but it was short.
And you had this situation in place that you referred to about the babysitter, right?
I don't believe.
You said in your statement that you had to get back for 3:10 to get your child off the bus, right?
Yes, I thought that because my phone had died and I was making sure I could get to them.
And so you really couldn't stay to watch the actual hearing,
I
could
didn't
you?
know my phone was going to die.
Nothing's ever your fault, is it? It's just a coincidence that your phone died, just happened to die, you didn't keep an eye on it? I'll withdraw that, huh? So you had this babysitter situation before you got there, and that's an indicator that you had to get out of there. Once you evicted Mr. Carney, you were going to have to get out of there and go pick up your child at 3:10, weren't you?
Objection sustained.
So your son was getting off the bus at 3:10, right?
Yeah.
And you live in Medfield at the time?
Yeah.
And that's about a half-hour ride from the Norfolk Superior Court, isn't it?
25 minutes.
25 minutes, sorry, we'll go 27 minutes. So you really didn't have much time to watch a hearing, did you?
They were going here and said they didn't know my phone was going to die.
And so it's your testimony that because your phone, everything was okay until your phone died?
Yes, children. I don't have a phone call.
She doesn't quit.
And you didn't want to rely on the babysitter, right?
She's standing on what she's been saying all along. She's not changing it, and she's not caving.
And she's not changing her tone of voice.
I mean, it's hard to hear. Thank goodness for CC, but
Yeah.
I hadn't met my kids before, so I wanted to make sure she completely recognized her. She recognized them. We thought things that was okay, even though I don't think it's that hard to comprehend.
So it was a helpful coincidence for you that the day ended at 2:10 or 2:15, right?
Sure.
And then you go to leave the courthouse,
Well,
right?
Yeah.
All right, guys, I'm gonna mark this timestamp this here.
Okay.
If they're gonna, there's court tomorrow with him. If I can find a live feed, apparently there's some, there is one. I might even come live with it tomorrow. I don't know. I was gonna take tomorrow, but I might if I could find that. I don't know, or the riot or the protest, not riots. I was thinking about Betty. Oh my God. Or the protest,
I agree, Kenna. Just for even being around her. He should have known better.
yeah.
And I think he did. He just didn't care.
Yeah, he toes that line and goes over that line all the time. All the time. And he's been doing it for years.
I was waiting to hear if her voice elevated in panic or upset, and I didn't hear it. She stayed pretty level in her voice.
Yeah, she did.
And she was right on it when he was asking questions.
Are they amping it back up?
His
LA's first night. Yeah, I knew a lot of people were going to get arrested because they weren't going to honor the curfew.
Right.
I'm sorry. Go ahead, Brady.
And that's okay. Not only that, she was also very right on her answers. And from what I was reading, she never changed anything. And when his body language, it wasn't just his body, it was his face and the way he was motioning his head that was intimidating and threatening. In my opinion.
But what I'm going to do is I'm going to, I think I'm going to come back and show some of the protests going on. It looks like, I don't know it says live, but it's starting to get dark there. People are sitting on the street. I think I'm gonna come back and stream some of these protests.
Okay. I'm going to drop down so you can do your thing.
Yeah, I'm gonna end it. Thank you guys for hanging with me. I appreciate you all. Mods, thank you. Thank you for the membership and the super chat and the PayPal. I appreciate that so much. Yeah, I think I'm going to come back and stream some of this. If you guys want to hang out tonight and watch the protest. I streamed it back and forth last night, but now I feel a little more comfortable with it. But now I know how to bounce back from the channels, but I can have multiple brought up in here. Oh, somebody just got arrested. All right. I'll be back in a little bit if y'all want to hang out. Thank you, everybody. See you, Misfits.